sure it was okay. Then he runs. That's it. 16 pieces of more. 16 pieces of more is cut off. Go back one more time, just where it gets cut off. Combined surveillance video. That's the one. What you know happens next is Relly, they're out of the picture now. Relly goes back and hits Hills again. 12 describe it for you. Why did that not make it into this video? Go ahead. Boom. Because I think this chair is through. There's a nail sticking out, by the way. Just so you know.
That wasn't me.
I know that wasn't you, John. That one I don't blame. Is there a bill I can send for this suit that you sent? Literally, there's a nail sticking out. Anyway, don't worry about it. Let me sit there. Not good. Okay. Anyway, the video, folks, the video itself by itself is reasonable doubt. It's a reasonable doubt in this case. Another reasonable doubt. It just makes clear that their case does not hold water, that Relly was the aggressor, that Rocky acted justifiably in self-defense bills, even though he was carrying a gun, those Hills will be dead. That was a real gun on that second shot. And again, Judge David trusts no self-defense. I have to discuss it with you. What matters is the defendant's perspective is what matters. And what he thought was right at the time. Judge David trusts on that, reasonableness and all that stuff. You have to listen to that. The prosecution must prove beyond a reasonable doubt that he did not act reasonably, Rocky. It has to prove beyond a reasonable doubt that he did not act in self-defense of another. If you have any questions in your mind as to whether he acted in self-defense or defense of another, if you have some doubt or some concern that he just may have acted in defense of himself or another, you have to stop. Not guilty.
It's what stating the law. It's true.
What's the state on?
Yeah, it's
I'm sorry?
it's what you said, it's not accurate. Here's a jury instruction that's already been given to you, and this applies to everybody. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions.
But I think I understand what Mr. Lewin's objection was. He actually was right. I said some doubt. It's not some doubt. It's a reasonable doubt.
That is right.
It's a reasonable. Okay. There we go. So, no swap. So if you have a reasonable doubt that he may have acted in self-defense of another, you have to stop. Okay? And the judge again will define to you what that is. Even if you get that far, because you should, because the evidence is so overwhelming, that was fine. If there's a possibility he acted in self-defense, you must find another. Rocky, now we gotta address this. Rocky didn't testify in this case. And you heard the judge's instructions about that the defendant has a constitutional right not to testify. We spoke to some jury selection about that. And that decision is not to be considered during your deliberations. With that said, during your deliberations, keep in mind that there was nothing more said than what was already explained to you by both our witnesses, who were berated and yelled at for a long time, hours. You heard from Twelby, who explained what happened that night, and Rocky carrying the prop gun. You heard from Lou Levin, who explained how Rocky got possession of the prop gun, why he carried it, and where it went. There was really nothing more, aside from the video, Twelby and Lou, for Rocky to have added to the truth about what
That's
happened.
an improper argument. It's just a-
Well, look, by the way, with regards to Twelby and Lou, you heard people say, and I expect they will say it again, the first time that we mentioned the prop gun was during this trial. This Detective Flores' testimony when they tried to ask her that or suggest that this had just come up. deposition in criminal cases, correct? Okay. Question. So basically, what you were being asked are questions related to discovery disclosure in a criminal case. And you said, yes. Okay. So these discovery related matters, and because Pitt received discovery notice, is not the same as it just surfaced at trial. Like it was just invented. That's not true. Lou and 12 Code today told us about this last year. And of course, Detective Flores told you law enforcement didn't have a chance to speak to Rocky after he was arrested. And of course, there's no idea.
That mistake.
No, who didn't say they had a chance to?
Do not debate.
I just said mistakes, the evidence.
As I said yesterday, I don't know what the evidence is. I don't think anybody remembers every word of every witness. If this is something significant, as I mentioned yesterday, you can ask the court reporter to read it back. The court reporter will have every word that has been spoken. Go ahead.
And of course, Detective Flores had no idea what was said by Rocky to his attorneys back in 2022 when he was arrested. And ever since.
That's also improper argument to rule aside the evidence.
In any event, there's absolutely nothing new, as they're trying to suggest. And look, they also brought up something that I now have to address, that Rocky had an outburst, so to speak, in trial. Okay? Knowing that he's innocent, he had to sit here and listen for more than 3 weeks, listening to relevant.
This is improper argument.
No, it's addressing what Mr. Krisloman had brought up in his argument. Overruled.
He had to sit here for more than 3 weeks listening to Relly say the most horrific, most offensive things about him in messages, calling him horrific names. He didn't say a word. He sat in silence. Always composed and respectful to this court and to you all. At some point during a minor, unrelated question, unrelated to November 6, 2021, Mr. Lou was asking 12 the meaning of an acronym in Rocky's bedroom. Rocky did something was a crime. He said, don't say. What does that do with his kids? It was personal to his children. And he asked not to say, okay. He regrets doing that.
Your Honor, there's no evidence in this.
Can you read that back?
Mr. Malone was asking for the meaning of the acronym. And Rocky did something that it was private. Said, don't say it, it had to do with his kid. It was personal to his children. He asked him not to say.
The jury heard what the question was. The jury heard what Mr. Mayers said. Leave it at that. Go on.
That had absolutely nothing to do with the facts of this case, the truth, what happened on November 6, 2021, whether he carried a prop gun, he didn't commit a crime. The fact that they actually argued that to you in their summation is indicative of just how desperate they are. That was something worth mentioning to you in their summation. Let's talk about the crime of extortion by Relly. That was actually proven in this trial.
Your Honor, that's improper argument. Overall, for legal conclusion, crime.
Overruled.
That's why Rocky told Relly in a text message that night, go to the police. Go to the police. But Relly didn't, not until he got civil lawyers 2 days later, because it was never his intention to go to the police. You heard that loud and clear. Instead, his end game was always to take Rocky's money based on false accusations. That was always his intention. And that's why that night, instead of getting the police involved, Relly, according to him, with his showcasing that he found, text the photos of his showcasings and knuckle scrapes to Rocky's manager, John Heyman, saying he was going to be rich. And that following message was sent to his own business partner, Justin Benea, saying, I want to get this end's money within minutes. That was in his mind. And you heard Relly complain in bitterness how Rocky didn't give him opportunities. So when the opportunity presented himself on November 6th, 2021, Relly jumped all over. Right from the beginning, Relly tried to get Rocky's money. Right from the beginning, without going to the police, without even going to a civil lawyer. So you heard from his own mouth what he knew that to be. Words so catastrophic to his claims in this case that his immediate reaction was to lie and say the tapes were fake. Fake. Get those away from me. You have to tell me over. Fake. But
so you called him because we were presenting fake evidence to you, yes or no? I don't know. This is a wonderful. I advise you guys to keep playing fake audio to like fake stuff. I never said none of that. It doesn't even make sense. It doesn't fit in with the tapes. You're trying to slip it in. Okay, stop. All right, check the question.
fake audio tapes. Fake audio tapes that the district attorney played yesterday with the Torella Farm name next to all his quotes. And the Torella Farm was sitting here yesterday, he'd be screaming, "Those are fake!" during Mr. Brzonowic's summation. I heard Mr. Brzonowic's say in his summation, who cares what he said? Wow, who cares? Did he forget the import of that conversation? That he committed perjury to you and said that they were fake when they were real? And during the cross-examination of Wally, the guy flew from Paris, by the way, honestly, because he had to be here. Okay, literally a 13-hour flight to testify, and then take another 13-hour flight back. And the question was, "You flew business class, didn't you?" Like, as if that were the reason he took 26 hours of plane to get here to testify. I had him on direct examination for 10 minutes because he was here for two things. Do you know anything about this case? I know nothing about this case. Good. Is this tape real? Do you make it? And is that your voice? And is that Relly's voice? Yes, it is. Bye-bye. Have a good flight back. No. 2.5 hours on cross-examination. But what was never asked on cross-examination, not even once? Is the tape fake? Is the tape fake? Did you doctor the tape? Not even once. By the way, the tape is spent, I don't know, the portion of destination playing for you yesterday. We provided to them. We provided them that tape. That they've been so helpful to them. They know those tapes are dead. Dead to their case. First of all, the main witness once again committed perjury on a most important issue in this case. Those are fake. He said fake. Get those away. He's a clown. Those tapes are death to Relly's claim and his credibility in their case. As Wallace and Jimmy made clear that anything but fake, you heard Relly tell him that you ask for a bag without a lawyer, bro, it's called extortion.
You know what I'm saying? You ask for a bag without a lawyer, bro, it's called extortion. You feel me?
But that's exactly
You
what
do everything accordingly.
That's exactly what Relly did. Because he didn't have a lawyer until November 8th, 2021. That he already tried to ask for money from Rocky and his manager. And after Relly lied about what he just told Wallace and Jimmy, we called Mrs. Jimmy just to establish the authenticity of those recordings. Nothing more. He knew nothing about this case. And because of the evidentiary rules, we were only allowed to ask Mrs. Jimmy about statements that Relly denied making.
No, that is untrue. Overruled.
So we had those 5 questions that we asked. Did he say this? Did he say this? Did he say this? That's the prosecution played other parts of the recordings afterwards. And it was not a gotcha moment. It's reviewing those tapes. At the time of their discussions, remember this, the Wallace and Jimmy discussions, that was in 2022, after Rocky's arrest already, after he filed his civil suit, well, they were about the events of November 6, 2021. There were of no significance at all what Relly said to him at that point regarding November 6th, at all. So in an effort to give weight to that story about the incident, those recordings, they played. Rocky was already arrested and he had already had a civil suit, claiming permanent disabilities from a bullet wound, and he needs $30 million. That was his story by then. Big deal, he said to Wally, in part. He still had no qualms lying to Wally at all on those recordings. When it suited him, of course, telling Wally that he was a millionaire and he made Rocky's career, that was on those recordings too. That wasn't true, neither of those things. But when Relly didn't lie about, however, what he didn't lie was about his intentions to pay Rocky's money, which is why he falsely said the recordings were fake. He knew what was coming. And he just said, if I say they're fake, they can't play them. They're fake, get those away from me. Tell the authorities, get away from me. So Wally Jr. was an IP guy who came for one reason, authenticate tape, period, end of story. First question I asked him, do you know anything about the facts of this case? No, I don't. He was not brought in here to talk about the facts of this case. But the prosecution, in 2.5 hours of course examination, asked him about his motives for making the tape. Is he better friends with Rocky? That's not being a very good friend for Relly. It doesn't matter what he made the tape. Who cares? He could have, whatever his motives were, who cares? He made the tape, it was real. Those were really Relly's words that he said were fake. Whatever his motive was, is irrelevant. Even if he wanted to help Rocky, he told you that's how it was, that Relly was trying to get involved, he was forward, whatever. But whatever his motives were, does it make the tape less real? Or Relly's statements less real? He was never asked one thing about those recordings being real, of course, which means they accept the fact that their witness committed perjury to you when he said they're fake.
That's improper argument.
Fair comment on your.
That should be offensive to anyone, especially to you, the jury, trying to make a decision of such importance in this case. It's a lot on your shoulders. That should be, you should be offended by that, I would say. So what did Relly tell us on those messages? His early text messages to Rocky when his manager, when they were trying to get money before his lawsuit, that he never cared about the police. He still doesn't care about the police. Quote, the end game, I'm suing the shit out of him. That's my end game regardless. I don't give a F about no police and those are his words on the tape. In fact, Relly only went to the police after his effort to restore Rocky failed. And Relly's civil lawyer said, unless you go to the police, I'm not taking your case. That's why Relly showed up at the police station in Hollywood with a civil lawyer standing next to him 2 days later. What victim of crime was the police station report a crime with an attorney next to him? Judge, want to do it now? Sure.
If you have 2 more minutes, use
Go
that,
ahead.
otherwise you can break.
Sure. Yep.
Say again?
I'll do 2 more minutes, just tell me when to stop.
And then we're gonna take.
Yep. As quick aside, you heard, by the way, the prosecution questioned Relly about telling the police he heard 3 to 4 shots, but only giving them 2 shell casings before having seen the videos, as if somehow that makes him more credible. That makes no sense. He was there, of course. He knew he was 2 shots. By this time, he already saw the video. He knows it's 2 shots. And in fact, he would exaggerate when speaking to the police. Does not make him more credible. By the way, when we talked to Wally, he had up to 5 shots. He had up to 5 shots when we talked to Wally. So before Relly went to the police, even before he went to a civil lawyer, you saw the messages he sent trying to get Rocky's money. Part of his plan to extort Rocky, Relly sent text messages to him, falsely accusing Rocky of trying to kill him. Obviously, Rocky knew that was false and was shocked that Relly would even make the claim, so which is why Rocky wrote him back. I tried to lie. Stop making shit up. He wrote him back. And now the prosecution has alluded to the fact that during this trial, Rocky didn't mention in his message anything about his prop gun. They don't consider one thing though about that. They don't consider one thing. Unlike Relly, Rocky didn't have a reason at the time he sent that message about stop making shit up. He didn't have a reason at the time, or think he needed a reason to create a record of events for some later date. At the time he sent those messages, Rocky thought they were between the two of them. And he knew why Relly understood his claim wasn't true, because it wasn't true. Rocky didn't shoot him and was aware that Relly knew he didn't shoot him because a prop gun doesn't shoot bullets. A spark pistol doesn't shoot bullets. Yes, sir.
Stop.
Okay.
You want to finish the thought?
If I could, just a thought.
Finish the thought, and then we'll take it.
And then that's a perfect place to take it. And that's why after learning soon thereafter that Relly was contacting his manager trying to extort money from him, Rocky was done communicating with Relly. He stopped answering completely and said, go to the police. And what kind of person tells someone to go to the police if they know they've committed a crime? Your Honor, I could resume from here and come back.
All right, we'll take a break until 11 o'clock, folks. Please don't discuss the case amongst yourselves or anybody else. And we'll see you in 15 minutes.
All right, so here we are. So he's still working on his closing argument. So once he's done, I'm sure they'll take another break. Maybe they'll be ready. Yeah, let me see, 11. They might go to lunch break before the state do their final closing or their rebuttal closing. So we'll see. So they're on a 15-minute right now. Okay, what's happening here?
The prosecution accepts their witness committing perjury. It's improper, it's unethical, you said you're not gonna tolerate it, and I object. And you make it clear to the jury that my objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what was said. You specifically.
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can to make sure that this trial is ethically conducted. They have repeatedly, I've objected, you told them it's improper. You overruled repeated objections where they are saying improper things. He just said a moment ago, this is a direct quote, the prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
What I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another. Relly committed extortion. There is no legal.
Do you think the jury's gonna ask for what the legal description of extortion is?
Your Honor.
Forcing someone to pay money, that is quote extortion.
Your Honor.
Forget, go on to something else.
Your Honor, I wanna make my record. I mean, you're gonna do what you're gonna do, but I have a right to make my record. No lawyer can get up here, and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. we've objected, and the court again is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter, and after a while, when there are so many of these things, they add up. And when the court is saying, well, what they don't care about it.
No, I didn't say they don't care
Well,
about it.
it's in, Your Honor, it's improper argument, and the problem is.
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion.
Your
You
Honor,
can address it.
Your Honor, the bigger issue, as I said, is the court was repeatedly told them, do not connect the prosecution to committing crime.
I'll tell you what, I didn't hear that. I'm gonna ask Kathy for the exact quote. If that's what was said, I'm gonna sustain your objection, and I will apologize for overruling.
Judge, I'd like to respond, please, on that one issue, not
Yeah.
everything else you said. What I said was, and I agree with what I said, but understand the context of it, okay? I didn't say this is more perfect, I didn't say it yesterday, I didn't say it today. The one thing I said, and it was fair comment, was the prosecution accepts their witness committing perjury. What I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relly saying the tape was fake. The tape was fake. They got up, cross-examined Mr. Sajemi, did not ask if the tape was fake or not, okay? They then put up transcripts of that tape recording with attributions to Mr. Efron. So that means by that, just by that very fact, they accept the fact that he committed perjury. I'm not saying they support it, but they accept that witness committed perjury. They have to. Let me finish. There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know it wasn't fake, it was real, that was perjury. So by then moving forward with it, arguing that the tape is important for the prosecution, that Efron said these things, that when they cross-examined Mr. Jimmy, that wasn't being a good friend, Efron made a tape. All that is doing is, I didn't say this is warning, it's different. I would never say that, I didn't say it yesterday. What it is doing is accepting it, because they didn't say, we have an issue with this witness, he's committed perjury. I said they accepted their witnesses committing perjury, that witness committing perjury on that one issue. That's fair comment, Your Honor. It's not inappropriate, it wasn't disparaging counsel. I didn't say Mr. Lewin, I just said they accepted, and that is true, that there's no other way around it.
It is not fair comment, it is completely unethical.
I agree with you.
So, Your Honor.
I agree with you.
What's frightening is Mr. Takina just stood up here and basically defended, said, yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear. And Your Honor, when it's happened 25 times in this trial, with the hiding of evidence, with the late discovery, and with repeated, you told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment, here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here and saying, well, yeah, I said it, here's why, just demonstrates again, he doesn't know the law or doesn't care.
You're disparaging him, right?
I'm disparaging him because, Your Honor, he's not following the
There
weirdness
is not to be any disparaging of either side.
during argument. The jury's not here. I have every right, obligation, and duty to stand up here and point out when he is being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'd be the first time. Court knows. I don't do that.
Oh,
Court knows. Court's already made
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur. I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would just move on and not make a, bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12, I have sustained 5. I'm doing the best I can, I will continue to do the best I can, and that's all I can say.
I just want to put on the record that, these remarks about being unethical, I've just about had it with him. This from a lawyer who, and I just say this on it, this from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California, when either he knew it was in California or had no idea that it was in California. Okay? So he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true. And that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Branford case.
Your Honor,
So
Your
I
Honor,
want to
Your
hear
Honor.
about him.
One more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so correct. Like,
You should be, Joe.
oh, yeah.
Let's take a break.
You should be.
Don't tell the court something, I was a liar. We'll do it.
Hold on, hold on. Hey.
Oh, yeah, oh, I'm so scared of you.
Stop it.
He said, I don't have enough of this guy. He said, I don't have enough now. Okay. When he trying to say this, when he don't know if the shooting range is here, he said, okay, Joe. Okay. He said, you think I'm scared of you? Yeah, if the judge don't, the judge gonna have to be on top of this one because he only get one shot at this closing. The defense does. He gets one shot at it, and that's it. And he's under a lot of pressure because he has one shot at convincing the jury. The state has 2 chances. So after he sits down, Lewin is going to get up and just go crazy. So he knows that. But look for him to object too. It's gonna get out of hand a little bit. It is. He said, "Stop it." It's gonna get out of hand just a little bit when I'm telling you right now, when Lewin gets up, he's already out of hand. Wait till he gets up and do his closing. There's gonna be so many objections that the jury gonna be entertained now. They're getting ready to. Because Tacopina, he's already under pressure. His client, you know what I'm saying, is nervous. So he's trying to land this thing, and you know what I'm saying, and he keep objecting to him. Because it's disrupting him, it's throwing him off. He's trying to break that connection with the jury. He always does that. They are getting ready to go at it. And they don't care about the judge at this point. They don't. The gloves are off. He said, you think I'm scared of you? Did you hear what he said when they were going to break? You think I'm scared of you? Something like that. He said, stop it. You can yell stop it all you want, but they getting ready to get crazy in front of the jury. Watch. Yep, they getting ready to. Because every time, like during his closing, Lewin keeps looking at the judge and making faces, shaking his head, and then he'll finally object. I know the judge is tired of it too. He gets one shot at it, man. So I see why he's losing his cool a little bit. Like, you got one shot, that's it. And I don't know if they're getting a read off the jury, looking at the jury's faces. I don't know. Maybe the jury is being stone-faced. I don't know. Or maybe they're not responding well. I don't know. But you can't really get a read on the jury. But I think someone said, will it be over today? It possibly could be over today. So after Tacopina sit down and then Lewin gets up, I don't know how long Lewin going to take, man. I don't. He might take the whole damn day, rest of the day. He might. I think the judge put a time limit on it, though. He may have said no time limit. he may have said that because I think the defense, they've been on well over 2 hours now, if you count yesterday. It's way past 2 hours, maybe 3 hours. So it may not be a time limit. So if it's not a time limit, then I don't know if it's going to end today. Because if he has his closing all the way to the end of the day, will they give the jury the case today? Possibly. And if they give the jury the case today, they could have a quick deliberation and come back with a verdict today. They could. But Lewin may take a god awful long time. And it's then you gotta do pause breaks for the fireworks because you know they're gonna go back and forth. Because Tacopina, he said he don't had enough of this guy now. He said he don't had enough. He's done had enough now. And they know each other. That's the funny part. He said, okay, Joe. So you think I'm scared of you? You think I'm scared of you or something? No, the judge, I don't know if he got strikes, but the judge, not the judge, the prosecution, the state is asking for 8 years if he's convicted. So he's facing up to 8 years. So I don't think the judge is going to max him out. Let's say if he do get convicted, I don't think the judge is going to give him the full 8 years. Could get 5 and be out in 2. Be out in 2 or 3 and do the rest on probation. But he don't want to spend no time in jail, to be honest with you. Just remember, the state, as a plea deal, they offered him a year in confinement, prison, and I think 1 or 2 years of probation. Or I forget if it was up to a year. It's up to a year they offered him, as far as the plea agreement. I'm not sure if he's been in trouble before. Only other time is in Norway. When something happened in Norway, but that's out of the U.S. jurisdiction. Remember, he was being held and Trump got involved. That's the only other time I've heard about him. But you could tell the lawyer is getting visibly upset. Because he's sitting there going through his closing and he feel like the continuity of what he's trying to do is being broken now because the guy keep objecting. So I guess he felt like he's not reaching the jury, or it's just like the connection is being broken because of all these disruptions. So look for the fireworks now. The gloves are off. And they're going to do it in front of the jury. They're getting ready to get wild in front of the jury. For sure. But yeah, I don't think he has any strikes against him. I don't think any of us follow him, real as it gets. I don't follow him either. I'm following his trial though. But as far as his personal life, no, I don't follow him either. I don't know his day-to-day activities. I don't. Oh, they offer him 180 days and 2 years probation, and he turned it down. Okay, thank you for the correction. So he looking at getting sentenced to like 3 to 4 years, something like that. I don't think he's gonna get maxed out at 8 if he's convicted. Have you ever seen attorneys go to blows in court? You mean fighting? I've never seen it. But it's happened before though. But I never witnessed it. It's happened in other countries too. But have I ever seen lawyers like straight get wild and arguing in court? Yeah. John Lewin last case. He was going at it with the attorneys. But they were like kind of laughing with each other too, though. But Tacopina was like, "Look, man, I'm about tired of this guy, man. I'm tired of him, man. I'm done with him. You know, he's sitting up here objecting everything. Like, I'm tired now. Think I'm scared of you?" The judge said, "Stop it. Stop it." Oh, it's getting ready to go down after the break. It's getting ready to go down. Because I think he realized he probably thinking Lewin, his objective is to disrupt him, but with all these objections to mess up his closing. Well, he needed to get fired up though, Tacopina, because he was kind of like, I don't know, not losing me, but it's like if you're paying attention, good. You know what I'm saying? If you're not paying attention, then I understand. So now that he's fired up, maybe that's what he needed. He needed to get fired up to wake the jury up because he was losing me. Okay, it wasn't Norway, it was Sweden. Okay. I knew it was one of them. That's outside of the U.S. jurisdiction, though. That don't count as a strike. Yeah, see, you fell asleep, right? I kind of nodded off too. So now that he got some spunk in him now, maybe that's what he needed. You know, he need to yell a little bit in court. You know what I mean? Like get animated. It's like, yeah, when Rocky had that conversation with ASAP Relly, his main part of it was, asking for money. When Relly was talking to 12 or the other people, he was mentioning money. Okay. He was mentioning money. So this was really motivated by money. It was really motivated. No, you can't talk like that. You got to act. Well, wait till Lewin get up. I guarantee you're not going to fall asleep. I guarantee you. Okay. You're not going to fall asleep. But if that other guy gets up again, yeah, that's going to be bad. You're going to fall asleep, yo. At that point, it's 50-50. It's still 50-50 at this point because I don't know what the jury is thinking. They may be thinking it's a real gun. If they thinking it's a real gun, he in trouble. But if they have doubts, then he okay. That's what it's going to come down to. Yeah, so okay, well, see, here's the thing. Do you have any doubt though, Mother Bird? Do you have any doubt? You said, I still believe it's a real gun, but do you have any doubt about it? If you don't have no doubt, then you're gonna vote guilty. Yeah, that's what we were saying. You said, in your opinion, if the gun was a prop gun, why hide it? In my opinion, the gun could be real. Now, do you have any doubt about it, though? Well, you say you haven't been watching the whole case, but if you don't have no doubt about it, well, guess what? Guess what? Guess what your verdict is going to be? Guilty. And I know, you got to get your feelings out of it. I know he got a family. I know he got kids. I know you don't saw the kids up in court. That was for a reason. That's why why do you think they brought the kids to court? So the jury can see the babies. Like, oh my God, there go his babies. That's why they brought him to court, man. Okay, so the jury like, damn, I gotta take him away from his kids. You know what I'm saying? That's why they brought him, man. At the very least, they need a hung jury. At least. They brought both of the kids yesterday. And then at the break, she I guess left him with the nanny. They didn't come back to court. You know what I'm saying? Brought both of the kids, man. So I would take my feelings out of it. I got to do my job. If I don't have no doubt that that's a real gun, then I got to convict him. But if I have doubt, then I'm cool with it. I'm going to say he's not guilty. All right. That's just the bottom line. Oh, yeah, he was arrested for attempted murder. Yep, in Grand Law. Yep, you're right. Yeah, he has, attempted murder. You're right about that. That was when he was about 16. Yep. I've heard about that. Thank you for sharing that with us, Dr. Ja. So he may have something wrong with his head. He might. See, I knew something might be, let me just say this. I don't know if something wrong with him, but he be wearing blouses and scarves on his head. You know, like the scarves like the old ladies used to wear back in 1960s. The scarf. I'm like, something, like, don't mess with that guy. Like, if some people dress like that, you better be careful. Like, that's why I wouldn't say, I would just keep walking. When he look at me, I just keep going, man. Even though he is petite, you know what I'm saying? It don't matter. What matters is what's in his brain. That's what matters. Okay. Because he's not, I don't think he's what do you call it? Sexually ambiguous. He just dressed like that. It might be something wrong with him. I don't know. But I would move on the side of caution with him.
I have no problem admitting when I made a mistake, and I made a mistake, and I'm going to tell you what the mistake was. Mr. Tacopina mentioned, and I missed this, the prosecution accepts their witness committing perjury. I missed that. There was an objection. I overruled it. I didn't hear the whole statement. I'm not accusing anybody of doing it proper, but that statement puts the prosecutors in an unfair light, and that was improper. I overruled the objection. I should have sustained it. I don't want any side being disparaged or being put in a false light. So I made that mistake. I own it. I apologize.
Thank you. Two things. One, I realized something. I said before that Mr. Efron said there were he'd seen the video, previously when he said there were 2 shots. What I was talking about was when he was speaking to Wally. He had already seen the video. This was obviously after Rocky's arrest and after the civil suit was filed. So I wasn't suggesting he saw the video when he went to the police on November 8th, in case that came out unclear. I hope that's what it is. So anyway, now we're back on the Wally's Jimmy case. Look, all I'm saying is this. Their witness said those are fake. They played it as if they were real. So, whatever that means. But here, I'm going to go back to the crux of the Wallace and Jimmy case, what we were allowed to play because they impeached the testimony of Efron. And what I argued to you, and what I'll say again, is the only crime that was proven here was relative extortion. He heard it from his own mouth. And he boasted to Mrs. Jimmy that he was getting $30 million. He said, I already know I'm getting 30 M's. And I told you at the beginning of this case, I said in the opening, that there would be clear evidence of extortion, and here it is.
You know what I'm saying? That's what back when I was lawyer first for extortion. Feel me? He's gonna have to deal with that and his political ties and everything else. Because once I walk away, when I get my cash, the case gets way weaker. It's just like a domestic violence case. If you was to hit your bitch and your bitch was to keep on going through with the situation, you go down. But if you're not there, then you're going against the state and it's way weaker.
Stop for a second before the second. You know, what he's saying is obviously he's going to trade his cash for the case, sell the criminal case. So he'll get his cash and he'll disappear. The example he uses, the analogy he uses, is disgusting. Of course, that's who, I don't know what front is, he's talking about a domestic violence case, and he references hitting, he said you're a bitch, but that's how his mind thinks. That's his example that he could come up with. But it really just goes to show you who he is and how despicable he is. And that was the example he gave. But what he's saying here is, I get my cash, I'm gone. I get them. Play the next one, please.
If I'm not there, he paid me out through my lawsuit.
Oh.
I'll walk away. Basically, it's gonna be called for the case because I'm gonna be on another highway. Just relax. You get what I'm saying? They're gonna be scrambling to find me because now they have to go against Rocky, the state, and here they have evidence in this and it's not gonna be the same when you present it to a jury and you don't have a complaining witness.
That's it. Game, set, and match. That's extortion. That's him trying to sell a criminal case for $30 million. That he will go to an island, be relaxing, if he gets his money. Too bad for them. They'll have to go look for him. They have to find him. Imagine poor Detective Flores having to go search around, looking for Carol Efron as he's on an island sipping pina coladas somewhere. For just $30 million. That's it. That's evidence of extortion. It's his mindset. He doesn't care about this. He just wants money. And you're his vehicle. The only reason, and by the way, this transcript's a little tough to read, I think, because I can't see it, but you'll have to go back with you and you'll have the transcripts. But again, remember, the only reason he's not on some island somewhere relaxing, and we're all here in the schoolroom, is because Rocky refused to be a victim of his extortion demands. It's that simple. And that's why he's using this trial, really, using these prosecutors. Now he's trying to use you to get him his money. Because he knows that a conviction here will get him what he really wants in the civil case. That's it. This isn't about justice for him. It's about a payout and a payback. My last quote of some of the greats in our history, using some of the words of our founding fathers, Thomas Jefferson, said an ancient trend is the bitterest of foes. We saw that come here, live and in color. lest there be any questions about his true intentions, consider this. He sent an article, you heard this testimony, to Wally Sajay on December 24th, 2024, just before this trial started, entitled, Rihanna Fears Heartbreaking Consequence of ASAP Rocky's Trial. And he sent it with a smiley face. A smiley face. This parasite is happy if he can hurt that family, that woman, and her family by sending a smiley face. Like, that's funny. That's funny. Because she fears the heartbreaking consequence of this trial. So he doesn't care about the trial, he just wants his money, he wants to be idle relaxing, and he's laughing and mocking what he can do to Rihanna family. And he needs you to get that done. Ladies and gentlemen, the prosecution has not proven this case not by a long shot. It's not even, this literally, I'm not telling you what to do, this can be a 5-minute verdict. You take as much time as you need. I'm not trying to impede on your promise. The only thing proven beyond a reasonable doubt is that this Lily is a pathological liar, a perjurer, and an extortionist. That's just been proven beyond a reasonable doubt. And they know that. They know that because they asked Nicholas Flores the question that I just never heard. I used to be a prosecutor. There was a question that they asked.
That's improper argument.
Sustain,
Withdraw.
but they know it's urgent. Sustain.
He used to be a prosecutor as well, Your Honor. It's not part of the evidence.
What was the statement?
What?
I'm sorry, what was the statement, sir? What was the statement? I didn't, what part?
If they know it's urgent.
I didn't say they knew. I didn't say they knew. I said what was proven beyond reasonable doubt, because he's that lucky, like a perjurer and source. Didn't say they knew. I understand the court's rulings.
Yeah, we objected regarding discussions in being prosecuted.
Okay.
Oh, yeah,
All right. So anyway,
sustain the best.
what they know, they asked Detective Flores this question. Would you agree, Detective Flores, that you don't need Mr. Efron's truthful testimony to establish a shooting occurred? Well, first of all, you do need it. You do. Remember, after breaking it down with Detective Flores, he made it clear to you they have nothing without him. We broke it down with him. We'll show you that transcript in a second. So you definitely need him, but he's just not credible. Why the heck do you think they asked that question? I mean, think about what that question screams out to you in the jury. We don't expect you to believe him, ladies and gentlemen. But it's okay. It's still true. No, it's not okay. No, it's not okay. If you had to make a decision, the most important in your life or of that of your family is on his word, would you do it? Terrell Brown's word, would you do it? You all know the answer to that question is. What you're being asked to do is make that decision in the most important matter in his life, on his word. Please look at the evidence carefully, please. Evaluate it cautiously. And you'll see that there's not proof beyond a reasonable doubt. Mark is innocent. It's not only not that he's innocent. An innocent man's on trial with absolutely no concrete evidence against him, no reliable evidence against him at all. Because he's innocent. He's not the luckiest man for the face of certain. Because there's absolutely no evidence of the shooting. And that heavy burden should not be yours to have to live with on this evidence. It should not be. It's not right, it's not fair. They ask you to do what the evidence won't, condemn an innocent man. And by the way, remember this, it's in your instructions, circumstantial evidence. If the evidence points to both guilt and innocence, You must, there's no option here. You must side with innocence. If there's two interpretations of the evidence, guilt or innocence, you must side with innocence. That's what the law is, Joe. It's in your little books. Jury instructions. You must. It's not an option. Terrell Efron, I mean, what kind of system, seriously, folks, do we have if this kind of witness came to take someone and destroy their life? With all you know about him at this point. I've talked about there not being any forensic evidence in this case, no fingerprints, no DNA, there's none. No independent evidence outside Terrell Efron. And ladies and gentlemen, the judge told you it only takes one lie under oath to throw this case out of court by you, if you choose. It's your decision. But just one lie. It's justification for you to say, I disregard all this testimony. You can't even count the number of lies he told under oath in this case. You can't. He lied directly, lied to your face, he lied under oath over and over, he exaggerated, he ran around answers to try and avoid questions, he verbally assaulted me, he cursed in the courtroom, he threw a water bottle, flexed his muscles, he said he had enough, he was gonna leave. How many does it take for you to know that this case is a fraud? To use Relly's own words, Relly's a fake. And he's just trying to profit off extorting a second. He's just waiting for one thing, your verdict. Then he's got it. And if they come up and say, well, Relly's not on trial, that thought crosses your mind. It's true, he's not on trial. He should be. He should be. Perjury, extortion. But he's not on trial. But what is on trial is his credibility. His credibility is on trial. And that you have to assess, and you get to assess. You must assess. The trial rises and falls on his word. With that in mind, again, I ask, what kind of system do we have?
Thank you, Howard, for the donation. That's for the coffee fund. Thank you.
The issue in this case is the life, future, and the real.
Thank you. Appreciate it. Can you hear me?
And that's what will be placed in your hands very shortly.
Appreciate it.
And the question you have before you first said, do you believe Tyrone?
Yes, indeed.
Tyrone Efron beyond a reasonable doubt? I'm going to keep saying that because it's really what we need to discuss, is beyond a reasonable doubt or not. If you don't, Rocky has to go for it. He can go home. He has to. We submit upon this testimony you've heard, the perjury you've witnessed, the lies you've seen, the destruction of pieces of evidence you've observed, the fabrication of others, Mr. Efron's trustworthiness, there's no way in the world that you can find that he's trustworthy beyond the reasonable doubt. There's no way. On the important issues in this case, so he wants you to find out. They lied about everything. They lied about the important issues. And if they can't do that, if anything they said to you, if anything they presented to you caused you to pause or wonder what really happened, if you have a doubt, a reasonable doubt, Rocky must be acquitted. He must be. That's our legal system. You just witnessed extortion demands throughout this trial of Efron, the lies, the hiding of evidence. The lying.
He's getting ready to close up, guys. I'll be right back. He's getting ready to close up.
The shell casings, on and on and on. And if you think he was lying about these important issues, the prosecution's case fails. Fails. So it's very simple, ladies and gentlemen. If you do not believe Terrell Efron beyond reasonable doubt, he must be acquitted. That's the law. A defendant in a criminal case is presumed innocent until the contrary is proved. In this case, it's not been proved. In the case of reasonable doubt, whether guilt is satisfactorily shown, until it is, he's entitled to prove. And the presumption placed upon the people that heavy burden of proving guilt is beyond reasonable doubt. Why is that standard called beyond reasonable doubt? Why? Look, there are many, I just want to give you some sort of analogies on this, but there are many legal systems around the world who don't have this proof beyond a reasonable doubt standard. They don't use juries, they use judges 1, 2, 3, sometimes 4. But our country has philosophy, and that is we cannot convict people who are innocent. We cannot ruin their lives because what happens is so harmful, devastating, brutal, based on anything but the strongest evidence. And what is being attempted here? It's so harmful, so brutal, so potentially devastating to him. That's why it's such a high standard. Standard is higher than what you find in civil cases when you have disputes over money or property. If you have a reasonable doubt about this case, about the testimony, about the double talk, about the lies, the perjury, the manipulation of evidence, the destruction of evidence, Efron's motives, it's over. It's over. You must acquit Rocky. According to the law, it's that strict. Our system isn't perfect. You still have examples of people who are convicted in DNA later exonerates them because well-meaning juries didn't have
This
evidence.
is improper argument.
So you have those, you've heard of those, it's like 250 less. There's nothing to do with this case, right? But it's by jurors who meant well, and they were subsequently exonerated by DNA evidence. Nonetheless, we have a system, and it's the best system in the world. It's the best system in the world here. It can't be perfect because human beings aren't perfect, but I'm begging you to honor that principle. Honor that principle of proof beyond reasonable doubt. Rocky must be acquitted under that standard with all the problems of falsehoods and the issues we've addressed. They cannot overcome them. They cannot overcome them. They can exaggerate. They can invert. They can mock the terminology of our witnesses. They can be sarcastic, repeating their unimpeached testimony. They can do whatever they want. They can't prove this case beyond a reasonable doubt. This case never should have been brought to begin with, based on Tyrell Efron, what they learned who he was. These are what we call burdens of proof in our legal system. In a civil case, again, it's a dispute over money and property. The one side that proves hundreds of the evidence, that's standard. They get the burden. Okay? And it's often described in very simple terms. If you have a scale, like scales of justice, if it just goes 51% to 49% in favor of one party, they win. That's a civil case. That's what the ponderance of the evidence. That's enough to bankrupt somebody. That's enough to take away their business, leave them penniless. It is not enough to convict them of a crime. There's even a higher standard than that in law called clear and convincing evidence. And clear and convincing evidence, for example, in custody disputes, for example, where the custody of a child is at stake. Clear and convincing evidence in some custody disputes, you can take a child away from the parent if you prove by clear and convincing evidence that that parent should not have custody. They have not met the standards for the legal system requires a parent. Clear and convincing evidence. Clear and convincing evidence alone is not enough to convict someone of a crime in the legal system. So take a child away, but not enough to convict of a crime. And let me ask you this: do you think you see clear and convincing evidence in this case that Tyrell Efron is truthful, that he's believable, that he's honest, that he's honorable, does not have financial motive in this case, that is to be believed and trusted? They can't even meet the clear and convincing standard, let alone the highest standard in our legal system, which is beyond a reasonable doubt. It's not even close. To further explain beyond a reasonable doubt, the judge gave some great examples in the preliminary instructions and how high that standard is. If you think someone may be guilty, that's not enough. If you think perhaps they're guilty, that's not enough. If you suspect they might be guilty, that's not enough. Possibly guilty, it's not enough. Probably guilty, not enough. Guilty likely, not enough. Guilty highly likely, not enough. It has to be guilty beyond a reasonable doubt. Ladies and gentlemen, when you get into that jury room, ask yourself, do we have a reasonable doubt about Tyrell Efron in this case? Any. Because all it takes is one. Just one. Just one. You have 100. All it takes is one. Look, my time is almost up. I want to apologize to you again, that this journey is taking. But you know, you're seeking justice that really are no shortcuts. You would trade this with me. You would want to fight hard and vigorously, especially if it was for a person who's maintained their innocence from the get-go, from day one. And I hope and I trust that you understand that in a journey towards justice, that there are no shortcuts. Let me tell you how this is going to proceed now. After I go after lunch, I think, or maybe now, the prosecution will go again for another submission, for rebuttal submission. We have this one opportunity to address you because they have this very heavy burden. So they go first and last. They will seek to rebut, which I brought up. Presumably, they won't be back up here talking about all sorts of new things, or they'll face objection. But they have to seek to rebut what is being argued right now. And let me tell you up front, I'm loath to object during someone else's argument. I won't do it. I didn't do it once before. Try not to do it, Mr. Lewis. But if something new is brought up, you know, it may be important. Let me tell you also this. If he brings up anything new, we may be precluded from standing up again and saying, wait a minute, here's an answer to that. Wait a minute, ladies and gentlemen, you have an answer. But you can substitute your common sense. You all can substitute your common sense. Your judgment in that place, and that's required for this journey. In this journey towards justice, you can substitute your common sense. You can respond for it. It's not out loud, don't do that. But you can respond. I'd like to remind you of something Judge Arnold told you. By the way, before I do that, I just want to also tell you that we're all very fortunate to have in this church. I've been before many judges. His patience with us in particular, his humility, he is an inspiring role model for what a judge should be. So you're all very lucky in this world. I figure. Anyway, as Arnold told you in the beginning, that Mr. Lewin will have the opportunity, the prosecution, Mr. Lewin will have the opportunity to sum up last. It's not because I lost the point was. It's not because of that. At the beginning of this thing. It's because that's the rules. They have the very heavy burden, and those rules established by the state. So because they have the heavy burden of proving someone guilty beyond a reasonable doubt, they go last, and that's a burden that never shifts to us. We have no burden. When a prosecutor has a particularly weak case like this, which stands or falls on evidence not worthy of belief, they always make some sort of pitch like, oh, the witnesses are on trial. I defy them to get up here and convince you that the evidence shows beyond a reasonable doubt that Rocky didn't act in self-defense or defense of another, or that the starter pistol was a real beyond reasonable doubt. I defy them to explain to you why. Watch for attacks on defense, watch for questions posed by him, knowing we're not allowed to respond. The law says you can't respond for me. One other thing I'm going to pose to them right now. Remember yesterday I was telling you about this issue regarding cartridges from a prop gun. Because you heard about prop gun can eject, does eject some sort of a casing. And I said to you, there's absolutely no evidence whatsoever regarding what blank casings from a prop gun look like. You heard evidence that from Lou Evans, who's the only one that was asked about it. There's paper and plastic in a prop gun bullet, so to speak. There's no evidence of how far or what direction they would be ejected to from the prop gun, whether they would still be intact or not, be split open. There's no evidence of that in this record at all. And certainly, there's no evidence that they would look anything like something that would be observable by the police, like those silver, shiny, metallic casings from a real firearm. No evidence whatsoever. I was told yesterday there was an objection. I was told I was missing evidence. I then said, first of all, I don't mistake the evidence, and I challenged the prosecution. Okay, if I'm mistaken evidence today, when they get up, show the jury.
Your Honor, this is improper argument.
If I mistake the evidence, show the jury when you stand up. That I mistake the evidence, show them the evidence in this record that cartridges on a pop gun are metal or metallic or anything. Anything. There's no evidence in the record at all. I'm still going to mistake the evidence. They could probably should. Now, it comes a time for me now to conclude my remarks, and I may never have another opportunity to speak to you again, certainly not this setting, maybe when the case is over. And you've been told many, many times there are very hard burdens based upon the prosecution of people for good reasons. Prove this case beyond a reasonable doubt. And as such, it is Stillwell's duty to answer for you as best it can any legitimate questions arising from the evidence which we believe is cast out on Rocky's guilt. There may be 1,000 such questions in a case like this, which we could put to them, but we intend no such exercise. We'll be here until the summer. I do think after careful deliberation that it might be fair to suggest 10 questions that literally hang in the air in this courtroom at this very moment. And as time approaches for you to decide this case, for us to hand the baton to you as you will, I offer these questions now as the most important challenge to the prosecution. The prosecution claims it's met this burden in this case. They claim that. Well, if the burden has in fact been met, then you'll be given logical, sensible, credible, satisfying answers to each of these 10 questions. On the other hand, the questions are overwhelming or unanswerable. Those questions will be ignored, or you'll be told that the prosecution has no obligation to answer our questions. If you're giving anything less than complete, sensible, satisfactory responses to these 10 questions, beyond the reasonable doubt, you'll quickly realize that the case is transparent and false, and false. We prove real hard things for you, things you can see, things you can take back to the jury room. And that is, you have to find Rocky not guilty. And when I'm concluded, and for Ms. Lewin's convenience, I should decide to deal with these very troublesome questions. I'm going to leave him the written list up here of questions when I conclude. Let's see if he wants to throw them or not, but I'm going to show you those 10 questions. Here they are. Let me go over them with you one by one, very briefly. Question number 1. Other than Relly's word, what evidence is there that he photographed shell casings at the scene? Okay, there is none. We know that. Because even though they had photographs from his phone, they didn't get the metadata to show where those photos were taken. We also know they didn't get his GPS location at 11:45 that was shown where he was when he took those photos. Number 2, other than Relly's word, what evidence is there that the shell casings even came from the scene? No evidence other than his word. Lydia Parker's not here. Let's talk about the metadata and the GPS location. Third question I asked him to answer. Other than Relly's word, what evidence is there that he even went back to the scene? Because now we know he swears that at 11:09, that's not him. That's not him anymore. And there is no video of him going back to the scene. So now we're left with his word again. Because they had Ill's GPS location, but not Relly's. Number 4. Other than Relly's word, what evidence is there that he ever left Los Angeles after going to a shooting range, shooting off 9mm, by the way, 2 weeks before the incident? Again, it's just his word that he left Los Angeles 2 weeks before. So he took a flight, and he took a flight back. That would have been a very easy one to prove. But we just have his word. Number 5. other than Relly's word, what evidence is there that the scrapes on his knuckles were gunshot wounds? He didn't have to comment on that. Number 6, other than Relly's word, what evidence is there that a conversation ever happened on November 5th, to set the tone for November 6th, between ASAP Bari and Rocky? Other than his word, there was no ASAP Bari, no phone records, so we just have to take Relly's word that that happened. Number 7, in light of Lou Levin's testimony and in light of Lou Levin and 12B's unimpeached testimony, other than Relly's word, what evidence is there that Rocky did not carry a weapon? Other than Relly's word? There's none. No evidence of a shooting. Nothing from either video says that's not a problem. None. Number 8. Other than Relly's word, what evidence is there that he was shot by an operable semi-automatic firearm? Again, other than his word, no evidence whatsoever. Number 9, this one's my personal favorite. Number 9. How is it that you do not need Relly's truthful testimony, remember that question, to establish a shooting occurred when Detective Flores told you, A, the parking garage video does not show an operable gun? That's his testimony. So let me break it down this way. Video 1 alone, you don't know if the gun's operable, correct? Correct. B, the video from 1616 Mrs. Omar does not show if there's any gun at all. The answer to that was specifically just looking at that and not looking at anything else? No. Well, that's the video. Just looking at that? No. And C, the sound heard on the video from 6200 Hollywood Boulevard may have come from a replica firearm, according to Detective Flores. So, no evidence of an operable gun in one video. No evidence of the gun at all or any shooting in the second video. And the pop, according to that case detective, could have come from a replica. So, do you need Relly's testimony? Because if you just don't have it, if you take it out, like was suggested in that question, Detective Flores told you there's no evidence. No evidence that there was a shooting or an operable firearm. And number 10, given that Relly told you he can lie whenever he wants, you saw him commit perjury multiple times. Relly told you that he will commit perjury when he doesn't want to answer a question. How can you trust Relly with a matter of importance in your life, the life of a loved one, or the life you sit in judgment of? I don't know how they answer those questions. They can't. I will leave these 10 questions right here. The city, if you get answers. I don't think so. Well, you have the capacity to transform this very dark 3.5 years into a bright tomorrow. You have that capacity. You have the power in your hands. It's up to you now. You're going to pass the baton to you now, or very soon anyway. And you will do the right thing, I'm sure of it. You made that commitment for justice, you'll do the right thing. I will go someday on other cases, no doubt, Mr. Lewin, Mr. Siegel, Mr. Brisloman, Mr. Kaplan. We will, Judge Arnold will try another case someday. I will. But this is Rocky's one day in court. By your decision, you control his very life in your hands. Treat it carefully. Treat it fairly. Be fair. Do the right thing. Remember the testimony of Terrell Efron and ask yourselves if you would trust him with any matter of importance in your life. And if the answer is no, you can't trust him with a matter of importance in his life. The case rises and falls just so with him. All you can do is try and get Rocky's life back. Imagine living under despicable accusation. 3.5 years. Facing what he's facing, knowing he didn't do a thing wrong. It's been my privilege, my absolute privilege, and honor to represent someone that I admire as much as And I thank his amazing family for putting their trust in me. You would ask questions in jury selection that if you had a doubt, would you have any problem saying not guilty? Would you have the courage to say not guilty? Did you have the mental fortitude to walk back into this courtroom if they failed to prove him guilty? You have the courage to walk back in here and say you find him not guilty. You all said you could do that. You all said it. That's why you were there. That's why the citizen of New York here. You know that's part of your job. You said you could do it. I'm going to hold you to that, and I hope you hold yourselves to it. That's what makes the system great. Your courage, your willingness to stand up for what's right. Look, this courtroom says Mark S. Arnold, judge. He's the judge. Judge Arnold's courtroom. But when it comes to the facts in this case, it's your court. When it comes to what's right in this case, it's your court. When it comes to what's fair in this case, it's your court. No one will take that from you. This is your court right now. I'm going to tell you something. What happened here isn't great. Think about that. Because if the message was going to be sent out, that proof like this is not to convict one of us, one of our citizens, none of us have a chance. Ladies and gentlemen, thank you for your patience. Thank you, Mark.
Take a break now, folks. Please be outside. The courtroom goes at 1 o'clock, at which time you will hear from Mr. Lord. Please remember, keep an open mind. We have not heard everything. Don't discuss the case amongst yourselves or anybody else, and we'll see you in about 17 minutes.
I had said yesterday, remember I said I thought I heard Rihanna, somebody said you crazy, that she was sitting near the camera. She's right near, like right there. It's like she got a very distinct accent. It's like I could feel like I could hear her in court. But she's there though. But I don't know if that was her, but she has that person that just said something had that accent. But we'll see what happens. So they'll be back at 1 o'clock. West Coast time. That's 4 o'clock East Coast. And then you know who's up next? Lewin. So they're going to get the case. They probably get the case today. Since it's 1 o'clock on the West Coast, let's see, he might do, let's just say he's finished by 3 p.m. West Coast time. They could possibly get the case today, or they could get it tomorrow. No, or they could get it Monday. Or they could work over the weekend. I'm not sure. They might get it tonight. Yeah, they might get it tonight. I'm just thinking about it. It depends on how long Lewin takes. I'm suspecting I don't know if they're going to get it today. I don't think so. I think he's going to take a while and they'll finish Monday. That's what I'm thinking. Yeah, they either late night tonight or Monday. It just depends on how long Lewin takes. I think he's going to take a minute, to be honest with you. Because he was animated throughout the whole defense closing. He was animated. So I would say Monday, they will get the case. Yeah, the jury, I would say Monday. You said Monday is a holiday? Maybe Tuesday. This could run into Tuesday. It depends on Lewin's strategy. If he wants to get this done early, he may be thinking that I'm going to condense this into, let me see, If he condensed it into 2 hours, they could get the case today. And then if they don't come to a decision, then it could go on to Tuesday if they off Monday. So that's what I'm thinking. He may want them to have the case tonight, though. He may. If he do, he might just spend an hour on it. Because he always looked back at the time. He always thoughtful of the time. So, but if not, he gonna spend all day with it, and then carry it on into Tuesday and finish up Tuesday. Then they'll get the case Tuesday to deliberate. He's from New York City. I think Harlem. Yep. ASAP Rocky. New York City. He's a founding member of the ASAP Collective. They call themselves the ASAP Mob, but here it's a collective. I like how they say that. We are a collective. We're not a mob. It's better to say collective than say mob in front of that jury. They're a mob. But I'm pretty sure if the jury, they're not supposed to research this case or listen to anything, but if they did, they'll find out that they're the ASAP Mob. But for here, they're a collective. It sounds better to say collective. It's a collective of musicians, of entertainers, and models. They're a collective. But they don't move like that, though. They act like they're a mob. But it's all for show. Most of the time, guys, it's all for show. It really is. Oh, man, he just passed? Yeah, it said he passed at the age of 63. He's an actor. The ASAP guys, the ASAP Collective. Okay. They are a collective. I like that. The collective. You said his father's from Barbados. Yeah, yeah. Yeah, he probably got that. I'm sure. A lot of these rappers are not they're first generation, a lot of them, according to Tariq Nasheed. Interesting. His father's from Barbados. And maybe that's why Rihanna hooked up with him, because she's from Barbados. So you saying ASAP Rocky's father's from Barbados? So that's why they got together. They got that Barbados connection. That makes sense now. Why she picked him. It makes sense. Yep, it makes sense, man. She is from St. Michael, Barbados. Yep, it says his father's from Barbados. His mother's from New York City. His father, Adrian Mayers, an acclaimed businessman and convicted substance dealer. Unfortunately, he was sent to prison in 2000 after being arrested for selling narcotics. And he died in 2012 after suffering pneumonia. He was still serving jail time when he died. The rapper says he admired his father, who was also inspired by him. Interesting. So that's why they, I guess Rihanna hooked up with him. They got that Barbados connection. For sure. Good afternoon. I remember this is a long time ago. This is when she was dating Chris Brown. Because Chris Brown, he's from out here where I'm at. He's literally from about 20 minutes from where I live. That's where he's from. And he used to come out here all the time. And when he used to come out here, he never had bodyguards because nobody bothers him, you know. And one time at my old college, he used to come up there to play basketball and work out, and she was with him. I remember that. I mean, people took pictures and stuff, but they didn't really mob him or anything like that. Because they used to see them all the time out here. She used to be with them. Yep, Chris Brown. I think it's a 50-50 situation that the jury could find him guilty. Because John Lewin is up next. Oh, boy. Oh, boy. He is up next. Thank you, Rose. Please smash the like button. That'll be greatly appreciated. Yes, indeed. It actually helps, when you hit the like, but it do help. It does. Yes, it does. It helps. Yep. Yes, it does, man. But it was only a few people taking pictures of him because he used to be at the college all the time playing basketball. And also he used to play basketball with the team. Like, you know, when they working out in the gym, he used to come in there and help and play ball. Because that's when I was taking classes there. And I've said what up to him many times. He used to be at the clubs and everything. Nobody bothers him. Not one person. And no bodyguards. Not none. Yep, not one. And D'Angelo lives out here too. Occasionally I see him. That's last time I saw D'Angelo, he was at the mall. Like he kept like looking at me like because he had a Maybach, right? And I was just looking at the car. I was like, okay, that's a nice car. And me and him was walking together in the mall. He said, "What's up, man?" I was like, "What's going on, man?" He said, "There ain't nothing." He went up in Macy's. We both actually went up in there. And we went in the same section. That was hilarious. I guess I wasn't following. He was walking behind me. It depends on, Michelle, it depends on how quickly Lewin finished. Because right now they're going to be back. They're going to start at 1 p.m. West Coast time. So if he takes an hour, he should be done by 2 p.m., right? They could get the case then. But I don't know. I think he's going to take a minute. I think he's going to take a while. Because he was animated during the defense closing. So you know he's going to have a lot to say. Yeah, Chris Brown is down to earth. He cool, man. That nobody bothers him out here. Nobody. Because he's out here all the time. So people are used to him. Like you'll just run into him somewhere. But now, not so much lately. Not so much. But when he was dating Rihanna, yeah, they were both out here all the time. Sure was. No bodyguards, man. They were just chilling. She working out. They would work out in the gym and stuff like that. And that was pretty much it. He still has a house here in Virginia. His mother has a house out here still. They have a lot of property, but he don't live out here. But he got a house out here though, for sure. They got a lot of land. I'm not sure what they're doing with it. I don't know if they farming. I'm not sure. It's been a while since I've been around there. Actually, no, I've been in his hometown near where he lives maybe a few weeks ago. I didn't notice, though, anything. Somebody still lives there, though. I'm not sure if his mother is there. Yeah, it's Tappahannock. I'm not sure if his mother still lives. I'm not sure. But his family's there. Somebody's cousin, somebody's there. It's a big house, and it's a lot of land. Now, if the jury comes back with a quick verdict, I would say that favors Rocky, but then again, guy, I don't know. I would think they would look at this thoroughly. You know what I'm saying? Look at this. They're going to take a while I would think they would take a while on the deliberations. They may have questions and everything else. Oh, you see running to MC Hammer? Shout out to Hammer. Hammer time. Oh, my ex coworker, right? She used to live in Chicago many years. She was working out there. She's not from there, but she was there for work. And one time she was in a restaurant and she ran into Michael Jordan, right? Now she had her niece and nephew with her. They were old enough to know who Michael Jordan is, right? So the kids didn't go up to him. He was sitting at the table and she went right before she left. She was like, hey, is there any way possible could you take a picture? Or he said no. Just like that. No. He didn't even let her finish. He didn't even let her finish. He said no. I'm at the table. No. Just like that. It wasn't like he didn't say it. He didn't yell at her or anything. It was just no, simply no. And then he looked at, he said no, and then kept talking to whoever he was talking to. Just like that. There's so many Michael Jordan is an asshole stories. It's hilarious. But I get it, though. If he's out eating, he's like, no. His autograph costs money. His likeness costs money. So, no. So, yeah, I get it. I told her, wait, well, you should have got him when he was coming in. He said no to other people, too, though. I was like, all right, so what you think he's gonna say yes to you? Like, yeah. But she mentioned the kids. Yeah, the kids would love to have nope. Nope. His autograph costs money, his picture costs money. No. And then the rapper Chameleonaire, he said that he had went to an auction and won some of Michael Jordan memorabilia, right? He was at a club when Michael was there. He said, Michael, hey, how you doing? I got some of your memorabilia and all that stuff. He said, what did he say? Can you take a picture? He said no. And he said, I don't like motherfucking rappers. He said this to him. He said, I don't like MF and rappers, right? And then I think it was either Charles Barkley or Charles Oakley or Penny Hardaway. Somebody was with him. It was more than one basketball player with him. And they kind of said to Chameleonaire, man, it's okay, man. Don't worry about it. And then Michael was like, nah, F that, yo. And he was getting tough with him. He was like, I don't like MF and rappers, man. Like, he got in his face like he was going to fight him. Like, I don't like rappers, man. So get the F out of my face. So then he was like so taken back by it, he was like, oh my God. Like I looked up to this guy, right? So he told the story, it's on YouTube, and he said Michael found out who he was. I guess Michael thought he was some random person, right? So the next day he received a letter from Michael Jordan, from the Jordan brand, and they sent him a bunch of autograph stuff and a bunch of sneakers. They sent him that. He was like, I apologize. You know what I'm saying? Like how I treated you. And so yeah. And then my boy, Born, he used to be a bodyguard. You know how like big homie CC, a friend of mine that I've known since, kids, he became a celebrity bodyguard too. And he got a Michael Jordan story. So one day he was head of security at this club in Charlotte. And it was Michael Jordan's daughter's birthday. And he didn't expect Michael Jordan to be there. He was told that the kids were going to be there. Like Michael Jordan's daughter and his two sons and their friends, right? So he was assigned to that detail, like to watch them when they're in the club in VIP. So he said when they got in there, I believe one of his sons like, hey, Dad, my dad is back there. He coming too. So he's like, oh, okay, damn, I didn't know he was coming. So then he said, when Michael came in, it seemed like he already had been drinking. So he gave him a dap or whatever. Like, what's up, big man? Like, whatever. And Michael went, to his, went to the VIP. And somebody came up to my boy, was like, yo, just be mindful. He's been in here before, and just make sure nothing happens to him. Because like he had a bodyguard with him too. So his bodyguard also met with him and say, look, we just got to make sure he's okay. And he was like, wow, what's going on? He said, just, he drank, So then this random dude that was in VIP went up to Michael Jordan and was like, can I get a picture? He said, I don't take pictures of no niggas. The F out of my face. Like at this point, he was yelling, man, get the F out of my face. Take no pictures with no nigga. He said, where the bitches at? That's what he said. He's like, what the fuck? He said, Michael Jordan, man. He said, this is like his airness, man, acting like this, right? He said, Michael act hood as fuck. So he was like, yo, Mike, mom, calm down. You know what I'm saying? I'm going to get the person away from you. He said, man, go get some bitches. He said, man, what's this dude around me for? Man, I don't take pictures with niggas. And he said he was just taken back by it. He was like, what the fuck? And then, so he said, Michael, he had another basketball player. I think it was either it was Barkley and Oakley, or maybe somebody was with him. Yeah, Jordan. Yeah, he said it was either Barkley or Oakley with him. One of them, it was another two basketball players with him. And they were chilling. And Michael was like, he was chilling or whatever. And then he was like talking to my boy. He was like, yeah, man, you know what I'm saying? I'm just chilling, man. You know, it's my daughter's birthday. He was not acting like Michael Jordan, like on the screen. He was not. He thought it was like a double or some shit. He said, this Michael Jordan brother or is it him? And then his brother came in too. And they were just chilling and whatnot. And Michael was just smoking a cigar, stuff like that. And he said he's been in that bar multiple times since. That was his first time, because he hadn't worked there that long, but that was his first encounter with Michael. And then he had a third and fourth encounter with him in Charlotte. And he said he was cool, but he don't like dudes in his face, though. And he will try to fight you. So that's why the bodyguards got to make sure he's all right. Like, just don't make sure he don't get in anything. Because he don't like randoms in his face. He just don't. But if he cool with you, he cool with you. He like, it's cool. You know what I'm saying? Like, if he dap you up, then it's cool. Oh, Scotty has nothing nice to say about him. That's unfortunate. That's rather unfortunate that they can't get along, because they needed each other. They wouldn't be who they are without each other, for sure. There would be no Michael Jordan without Scotty. No Scotty without Michael. They were like Batman and Robin, man. But it happens, though. But yeah, Michael, the dude said, yo, man, what's up, Mike? You know, like all in his face. And he pushed him. He's like, man, get the hell out of my face. I'm like, ain't words in my face? Hell out of my face. Where the bitch is at? Oh, man, Jordan. And, you know, Jordan is a big dude. You know, he's like 6'5", 6'6". My boy is like 6'7". He was like Michael, just as tall as he is. So he was like, and he's big. So he ain't no punk, you know what I'm saying? He was like, yeah, get out of my face. But he was like just having a good time, you know what I'm saying? He was in VIP. Then his daughter's ready to go. Then he left with his daughter and them. But and then it was this car wash. It was this mobile detailer guy, right? He told a story about Michael Jordan in Charlotte. So he's a mobile detailer, right? So he was assigned to, he didn't know he was going to Michael Jordan house, but he knew that he had a gig there. So when he got there, Michael he didn't come out yet. Like one of his sons came out or something. Then he's like, okay. He said, it's Michael Jordan. So then he said, next thing you know, Michael come out of nowhere. What the fuck? Nick, what you doing here? The fuck? He said, what you doing here? And the guy was like, damn, I'm here to detail your car, Mr. Jordan. He said, man, fucking call me Mr. Jordan. He said, what you doing here? The fuck? Like, he was like raising up on him. Like, he might have had a gun on him and everything. Like, just like barking at him. And then the dude was like, look, Mr. Jordan, I can leave, but I'm here to wash your cars. He said, oh, okay. He said, you here to wash my cars? He said, oh, my bad. He said, what happened with the other dude? He was like, nah, I don't know. But then he said Jordan gave him a bunch of sneakers and everything as well. And they became cool after that. Yeah, Jordan off the hook, man. He looked like he is. He looked like it. Yep, he looked like it. You know how, like, when he's on regular TV, hey, guys, I'm Michael Jordan. Yeah, I'm Michael Jordan. Hell, oh, yeah. No, he's not like that. Michael got some thug in him. He do. And he old school with it. Just don't get in his face, man. That's why I don't be in celebrities' faces like that. I don't. I remember I got a story for you one time. I was in New York City and I'm just walking and it was like a bunch of people out there taking photographs. I was like, okay, it must be somebody famous about to come out. And so they had like a little red carpet kind of thing. And it had like the SUV waiting. I said, okay, well, let me and they had the big bodyguard standing there. So I said, well, I'm not going to get in the street. Why don't I just walk by? So I'm trying to walk by, and the guy he grabbed me. He said, hold on. You have to wait a minute. Hugh Jackman is coming. I said, what the fuck? I said, where? He ain't coming yet. Let me get by, yo. No, you cannot get by until Hugh Jackman gets in his SUV. I said, what the fuck is this? I said, you act like he's the president or something. I said, let me get by, man. And then people started laughing. I said, I don't give a damn who it is, man. Let me get by, man. I said, what you talking about, Iron Man? And somebody said, yeah, Iron Man. I said, Iron Man. Okay. No, not Iron Man. What did Hugh Jackman play? Wolverine. I said, is that Wolverine? What did he play, y'all? Because I remember saying it. It's either, oh yeah, happy birthday to you. It's your birthday. Happy born day. I said, what, this Wolverine or something? I'm like, man, let me get by, man. I said, let me get by. I don't give a damn. I said, matter of fact, let me just stand here then. You know what I'm saying? And take my camera phone, no pictures. I'm like, well, so what? Let me get by then. The fuck? He didn't even come out the restaurant yet. And the people were laughing. That was hilarious. Then he finally came by. I said, they go Hugh Jackman and shit. I have to stand here until he get in his damn SUV. The fuck? He said, hold on. You have to wait right here. Hugh Jackman is coming. That was crazy. Simply Lee, the red, the black, protected by the red, the black, and the green. Sissies. When I see that picture, I say that it is protected by the red, the black, and the green. Sissies. I don't know if you remember that saying, X-Clan. I don't know if you remember that. They used to say that this is protected by the red, the black. Oh, you remember that? X-Clan. Yeah, it was X-Clan. Yeah, X-Clan. A friend of mine, she take care, hold up, I'll tell you his name now. When I think of that fist, you remember the 1972 Olympics? When the track runners, they held their fist up? She take care of one of them now. He's a nurse. She take care of one of them at his house. His name is Tommy. Hold on, I'll tell you right now. His name is Tommy Smith. I believe it's Tommy Smith. Let me see. Hold on. I'll tell you right now. Yeah. Tommy Smith. And the other one was John Carlos. But yeah, Tommy Smith. And she didn't know that he was a part of that iconic photo until his wife said it. His wife mentioned it. But you would have never known. But he talks about, he's still with it. But she says he's a very nice old guy. And once she found out, she started asking him stories about his track life, and he started talking about it. And he was a part, and they have one of the original photos in their house. That's a very iconic photo there, the black fish photo. Actually, it was at the 1968 Olympics. What's up, Cyrus? We waiting to 4 o'clock here, East Coast time, 1 o'clock, West Coast time for John Lewin to take center stage. Because it's getting ready to be fireworks. Because they're already beefing with each other now, the two lawyers. He said, I ain't afraid of you. Think I'm afraid of you? I'm not afraid of you, man. The judge was like, stop it. Stop it. You said happy birthday. Oh, yeah, it's your daughter birthday, Rose. Happy birthday. Happy born day. He was like, stop it. Stop it. Just stop it. So you just know that they're going to have some fireworks. Just know that. Because the defense lawyer, he wants his get back. So he's going to be objecting to everything, pretty much. They expect a few objections. Because Lewin gonna get up there and he's just gonna go the distance. I'm telling you. So Rocky, if he gets out of this, he got out of this with his life. He did. He narrowly got out of this one. You gotta thank his lucky stars, man. Lewin was trying to get him. It wasn't lack of effort. He tried to get him. Barely got out of it. So he need to buy his lawyer all expenses paid trip to wherever he want to go. Like, for real. That's what I'll be like, sir, I got you. Wherever you and your wife or your family want to go, it's on me. It is on me, and we're family now. We fucking, because he went the distance for him. He did. He said it was my honor and privilege to represent somebody that I admire. I love it. It's my honor and privilege to represent somebody I admire. But Lewin is relaxing right now because he getting ready to go for it. So, and the judge is, having a little bit of lunch, relaxing, getting his mind right for Lewin and the other attorney. He getting his mind right because he knows it's getting ready to go down. It's getting ready to go down, man. Now, he better hope that Lewin don't get up and the other attorney get up. He better hope. If the other attorney get up, then I'm like, okay, cool. Everything should be solid. But if Lewin gets up, which I suspect he's going to get up, it's going to be a problem. It's going to be a problem, man. It is going to be a problem. See, my whole question, because I know, let me see, as Real as It Gets, I'm not sure if he's still here. Real as It Gets had, why? I don't know if you said, why is this case going on? Like, what's going on? I think somebody said it. That's what we were all thinking, because if it was a prop gun and the police never found anything at the scene, as far as shell casings, and there was no evidence of him going back and picking up shell casings. And why are we here? Why are you here? Okay. Like, why are we here? Right. You got to think about that. If it was a prop gun, why are we here? Right. Even if they don't produce the prop gun, right? They don't have a weapon. So, the scrapes on ASAP Relly hand, I'm not sure if it was from a bullet. I'm not sure. None of us are. This was a case where I'm like, yeah, I don't know if they should waste the taxpayers' money on this one. But what they did was they brought in John Lewin. So I said, okay, maybe they're thinking that it was a cover up here to bring him in, because they brought in a heavy hitter for this case. So I really believe they think he had a real gun. That's why. And California don't play when it comes to that. They don't. You say you might pour a glass of wine for this? Oh my God. Lewin, I'm telling you, he gonna start off smooth, right? He gonna start off smooth, and he gonna say something the defense ain't gonna like. I'm telling you, he is. He said, this man over here guilty. He don't bring no prop gun to no fight. See, he's gonna be where you're not gonna fall asleep. Okay? You're not gonna fall asleep. It's gonna be straight theatrics all the way through. He's gonna start off smooth though. Okay. Thank you, jury, for being here. Thank you very much. Okay. It's gonna be professional at first, and then he gonna get to it. So my thing is my opinion is, I think it's a real gun. I thought it was a real gun. Like, if it was a prop gun, you would have produced it. Like, because you're not going to get in no trouble for that. You probably get a slap on the wrist. You probably get some fines, maybe misdemeanor at best, at worst, right? He ain't gonna get no jail time. So why not produce? Because they don't have the prop, because it was real. That's why. And in their text messages and their conversations after the fact, nobody mentioned a prop gun. Nobody. Because I would have said, look, Relly, it was a prop gun, man. He didn't mean no harm to you. He just wanted to scare you. It was a prop gun. Nobody said that. That's because it was real. Now, if the jury believes that, he's in trouble. If the jury believes that, he's in trouble, man. But it ain't what I think. It's what the jury thinks. So I'm going to keep it at that. And then they say that the reason why he had a prop gun is for protection. Ain't nobody carrying no prop gun for protection, man. Like, if somebody come up to you, what if they got a real gun and you sitting up there with a prop gun? No, nobody does that. That don't make sense, man. You don't leave your common sense at the door. You don't. No, but see, that's what Lewin wants, Howard. He wants a back and forth. He does. He wants to fight. He wants that, and he's going to do it right in front of the jury. He's done it before. He did it in the last case I followed with Robert Durst. He did it before. They were laughing in court. They had the jury laughing. It was crazy. Even the jury was laughing, yo. He had the jury laughing. Even the defense team was laughing. Everybody, it was crazy. Even the judge was down with the shits. Even the judge. The judge didn't say don't do it. He was arguing back with him. The judge was. That Robert Durst case was crazy. You said, Max, I am a woman. Oh my God, I'm sorry, real as it gets. I don't know. I'm just thinking, you know what I'm saying, real as it gets. That's the homie, the dude, you know what I'm saying? Then you say I'm a female, I'm a woman, Max. Damn. My bad. I mean, this is not the first time me and you had this conversation. That's crazy. But, I don't got nothing to go on. It's like, it's an R there, and it's real as it gets. You know what I'm saying? I'm thinking it's a whole dude, though. Real as it gets. I said, where is he at? Where real as it gets at? And she's like, and look, and then now I feel crazy. Like, at Max, I am a woman. Like, damn, now I feel crazy, you know? All right, well, I have to try to remember it again. This is not the first time you said this to me. And somebody else said that to me too. Max, I'm a female, Max. You thought the same too, Howard? Okay. So that last trial Lewin was in, he got a conviction, but it was just fireworks after fireworks. Even the judge was down with it because the judge is famous too. And they're all good lawyers, all of them, even the judge. And they were all arguing with each other in front of the jury. So then the judge like, must we do this here? Mr. Lewin, must we do this? He said, Judge, I'm trying. He said, must we do this here, though? He said, please approach. He said, because we're sitting here in front of the jury. We need some decorum in this courtroom. We need some decorum. We need some professionalism. Man, they were going at it, man. That man finally got convicted, Robert Durst, before he passed. It was a cold case file. That's what he's known for, cold cases. And he was, convicted of killing Susan Berman. And Susan Berman, that was back in the 1980s or 1990s, something like that. But he was getting ready to prosecute him on his wife that disappeared in the 1970s. And he was going to win that case too. But see, Robert Durst was sick at the time. I didn't think he was going to make it through trial. But then when he got convicted, a few months later, he passed away. You said just sipping on some wine, y'all stay safe. Well, it's about to go down with Cyrus in a minute. It really is. It's getting ready to go all the way down. The defense attorney said, you guys do the right thing. Got to do the right thing here. And he only had one shot at it. And Lewin been typing the whole time. Typing. So something getting ready to go down. He's been shaking his head, objecting. So it's going to be, and he's going to get his get back, the defense attorney, I'm sure. But yeah, man, it's a fight. So if Rocky get out of this, he need to thank his lucky stars, man. Like, for real. Because he almost got convicted. I'm going to say that. He lucky, man. I'm thinking he going to skate off this one. But if that jury feels that it's a real gun, though, he's in trouble. He's in trouble. Because they don't have to prove that he shot the gun. You remember how they don't have shell casings. They don't have to prove that. Well, they don't. See, the thing is, Relly claimed he found something, but they don't have to prove that. They have to prove that he pulled it out. That's where the crime was committed. That he pull it out. That he show it. California ain't no joke when it comes to that. But if they feel as though he shot as well and is a real firearm, yeah, he getting convicted. They're going to find him guilty. Now, there could be some jurors that's hung up on this. It could be a hung jury. Yeah, we call him the pit bull. The pit bull, yeah, he's relentless, man. He was getting at the judge. The judge said, don't yell at me. I warned you, don't yell at me. Don't yell at me. He yelling at the judge is crazy. He did it in front of the jury. Good afternoon. Good afternoon. He yelling in front of the jury. He don't care the jury listening. Like, that's the way he is. So we getting ready. It's like the calm before the storm right now. He's going to start off smooth, though. Just to let y'all know. He going to throw y'all off for a minute. Thank you, jury, for being here. Thank you very much. Thank you for listening to this case. And for the whole 5 minutes, everything going to be fine until he start to, like, walk that tightrope and piss the defense off. Because that's what he gonna try to do. Oh, Bill, it's your birthday too? Damn, everybody birthday today. Happy birthday, Bill. It's your birthday today? Happy 360 degrees around the sun. Happy Earth Day. Or as we say, Happy Born Day. Or we say, Happy Solar Return. Oh, Diddy court case. His lawyers are gonna go viciously after Cassie. They're gonna go after her. They're gonna be like she enjoyed it, and they're gonna try to embarrass her on that stand. They're gonna go for it. They're gonna come for her for sure. They are. They're gonna be like, you lying. It was a money grab. You wanted $30 million at first off that book deal, and you wanted, you approached them on that. Now all of a sudden you come in with a lawsuit. They're gonna tear her a new one. They definitely is. They gonna come for her, man. She got to be ready though. Oh, you meant happy. Damn, I can't read, yo. You did say Happy V Day in the beginning. I just can't read. Yeah, happy Valentine's Day, everybody. Imagine going through a case on Valentine's Day. It's crazy. But it is what it is, man. No, it ain't his birthday. I read it wrong, Mother Bird. She meant Happy V Day. And she did say Happy V Day. I just read it wrong. I had a glitch. It was a glitch in my digital downloads. My solar downloads, I had a glitch. Like a glitch in my matrix. That's what it was. The download, I just had a glitch, so I had to recompute. You said Happy Stupid Cupid Day. Yeah, John Lewin is trying to mess up everybody's weekend. That's what he's trying to do. He's going to try to mess up that kid's weekend. That everyone's birthday is today. I know. I had a glitch. I literally had a glitch in the matrix. I'm taking V Day as birthday. It's a glitch, man. I'm glitched out today. That's what it is, Rose. I'm having a glitch right now. Let me drink some water. So as we wait for them to come back, what to expect here? We expect some fireworks, like I said. We're gonna expect some fireworks. We just don't know when it's gonna happen, but it's gonna happen. Because if you missed it, they already had a confrontation already. This was outside of the jury. he was like, you know what, Judge, I'm tired of this. I'm tired of this guy here. I'm tired now. Like, you know what? And then when they were walking off for break, Tacopina said, I'm not scared of you. And then the judge was like, stop it. Stop it. He said, I'm not scared of you. So yeah, they having a problem with each other. Yeah, they're definitely having a problem right now. So you said your third grandbaby was just born today on Valentine's Day. Oh, congratulations. Yeah, so um it's going down soon. Just can't wait, man. Case is finally gonna come to an end. It was a kind of risky case to take, though. And even though they were offering him only a few months in prison, arrest, probation, is crazy. But I see why he took it to trial, though. Because if he think he really had a prop gun, yeah, but they should produce the prop gun, though. And the only other thing is, the person they claim they gave the prop gun back to, he ain't nowhere to be found. So, and they didn't talk about no prop gun to each other. So that's going to be a problem. You said like get kicked out of. Nah, he's not going to kick him out, but they just going to go back and forth. They going to go back and forth with it. Yeah, because they know it's real. Real firearm, man. I watched some of the Young Thug. I don't know. That trial was so damn long. I couldn't even watch it anymore. I was watching highlights. Speaking of that trial. You hear it? It's the calm before the storm. That's what you're hearing right now, the calm. The calmness before things get crazy. We got 12 minutes. All right? 12 minutes before things just go all the way crazy. Now, we'll see. But I'm pretty sure because he had a lot of objections and he's probably going to, because they get one shot at it, he's going to straight up say the man's guilty. And yeah, he better hope that other guy get back up. Lewin gets up there. Yeah, it's going down. Yeah, the judge said be back at 1 p.m. You ready? You say you ready for it, right? Yeah, a lot of people ready for this. They're ready to see what the possibilities are. That the court system love their lunch breaks. Yeah, I would be on the edge of my seat too. It's a hell of a gamble, man. It is. Whew. I don't know, man. If I know I had a real gun, but see, it's a lot riding on this too because of the civil case. So I think he probably just anxious. Especially when the jury get the case, then you really get anxious. Because they come back with questions, and then you thinking like, what does that mean? What does that question mean? What are they thinking? Why are they asking that question? You see what I'm saying? Like what do they mean by that? So yeah, things is like rather intense, man. I understand. Let me see. Yeah, they if he's convicted, the prosecutors are asking for 8 years. So you got a lot riding on this, folks. Got a lot riding on this thing, man. I remember I had originally said 20 years. No, that was false. It's 8 years. So I had to, I stand corrected. Because I was like, wait a minute, that seemed like that's too much damn time. No, 8 years they requesting if convicted. If he's convicted, will he receive the whole 8? I don't think so. But I'm leaning towards the jury. I mean, because if there's doubt, you can't convict him if there's doubt there, man. Yeah. Let's just see what Lewin does. See what his presentation look like, which I know is going to be good, but at least it's not going to put you to sleep. I tell you that right there. So we'll see what he does. And it's up to the jury at this point. If they feel like they have doubt, then Rocky is good to go. He don't have nothing to worry about. Well, he won't know. I mean, he's going to worry, but you know what I mean. I thought Eric Adams, wasn't he supposed to be getting a pardon or something? He didn't get a pardon, did he? He didn't get a presidential pardon, did he? I didn't hear about him getting pardoned. I know he was looking for one. But here's the thing about the tape conversation. The tape conversation didn't help Relly's case, but they didn't mention a prop gun, though. See, that's what I was waiting for, like somebody to say the gun was fake. Oh, the Department of Justice told them to drop the charges. You said, how did Tory get convicted? It was his lawyer's fault. His lawyer. Because remember, the last defense witness in the Tory Lane case said that he saw Tory shooting. That was a mistake. It's on his lawyer, man. I was like, wait a minute, is this the prosecution witness or the defense witness? It was a defense witness. Yeah, he said he saw him shoot. Yeah, and they said the lawyer was connected to Jay-Z lawyers. You said the Department of Justice dropped charges on him yesterday? They dropped the charges or they... Nature Boy was... Yeah. See, the thing is, Relly did say too much. He did. And he did act a fool on that stand. But however, that video shows him with a gun in his hand. That's the problem. That's the problem. So if the jury, like I said, like, all right, well, simply Lee, like the way you're putting it, you would have to vote not guilty. You would have to, because you got doubt. You have doubt. So did you know, like I did a poll here, it's rather close. It's 50-50 here. Some people say a conviction is coming. Some people say no. And then about 17% said hung jury. So it's rather even right now. So I think it's 50-50. But if you think it's doubt there, I'm not arguing with you there. I'm like, okay, it's doubt. One of the DAs in resigned over the Adams case. Yeah, ain't nothing gonna happen to Adams. He got Trump's back, and Trump got his back. And he also is down with Trump and helping out that immigration situation in New York. So he got his back. The mayor got some connections, man. Uh-oh, guys. It's 1 minute to go now, guys. Let's see if they come back on time. All you need is one person having doubt for it to be a hung jury. But that's not what they're going for. They're going for a full acquittal. And I'm going off of what you said right there. Like, you're on the side of not guilty, simply, Lee. A lot of people are. A lot of people, because of Relly acting the way he was acting on that stand. We don't know if his wounds on his hand was from a bullet or he scraped his hand. You know, there's questions there. Was it a prop gun? I don't, so some people might say not guilty. If you got that doubt, you got to say not guilty. You have to, regardless of how you feel about the person. If you got doubt, not guilty. He said if he's found guilty, it's because of them pushing the prop. Right. I'm thinking the gun was real. Okay. How come you can't find the prop gun now? All of a sudden, conveniently, you can't find it. Okay, conveniently. You can't find the prop gun. That prop gun would have prevented him from going to trial. Like, all he had to do, listen, all he had to do is call his lawyer real quick after the incident happened. Like, look, I crashed out. I threatened somebody with a prop gun. The lawyer would have took good care of it. He said, okay, I know the law on that. Okay, so hand over the prop gun to me, and I will make sure everything else is taken care of. That's all you had to do. When you got that kind of money, you have to have lawyers on speed dial, just in case. Like, what do I do here? Yeah, because it was real. And if they think it's real, that man is getting convicted. You said at Max True, because the wounds didn't convince me. Right. See, if they're not convincing you. But see, here's the other part to it, simply, Lee. The wounds are not convincing me either. I don't think the wounds convincing anybody. But was that gun real, though? Now, if you have doubt on that, yeah, you have to say not guilty, regardless of how you feel about anybody. You said hardcore homies don't carry a prop gun. They said he did for protection, Bill, because his home was broken into. He had to carry a prop gun. It would have been better for him to get a real gun in LA, because he's a celebrity. He would be able to carry a gun because he's a celebrity, for his protection, even though he should have bodyguards. But here's the thing, though. Celebrities, not everybody want to have a bodyguard around all the time. Did you know that? They don't want that all the time. Have somebody all in their business with them and all that. Okay, here we go, guys. So I'm going to shut up now. Well, let's wait and let's see. Yeah, I'm going to shut up as soon as it get going. As soon as it get going, that's it. I'm on mute now. I'm just going to type the rest of the way through. And I ordered something to eat because I'm feeling a little bit weak because I haven't had anything to eat. And I'm on this weird ass diet. And I know it's supposed to be mind over matter, but I can't play around like that. Oh, you know what? I forget I had that. I gotta eat. I gotta have something. So I'm gonna sit here and enjoy my. Somebody said they got wine, so enjoy your wine. If that other prosecutor get up, I'm gonna be let down. Like, we waiting for Lewin, man, and I believe the judge said Lewin. I believe he did. Does that other prosecutor get up? Okay, I'm gonna be let down, yo. Like, for real. If Lewin don't get up, I'm gonna be let down. That means that they're not really caring about Rocky getting convicted. But no, they do care, because they wouldn't be in the courtroom wasting people money. So, but John Tacopina, he's ready to go. You said his ego won't let him not have the last word. We'll see, Simply Lee. We'll see. Yeah, he do got a hell of an ego on him. He do. That man got an ego the size of the Gulf of Mexico, the Gulf of America. Look at that. I'm about to say Gulf of Mexico. They got this Gulf of America now. Man, did you see Trump yesterday? It was hilarious. He was meeting with the Indian, I forget, the president or something. This guy was trying to ask him a question. He's like, I can't hear you. I can't really hear you. So then he said, repeat it. He started talking again. Trump was like, I can't understand you. You know what I'm saying? I can't understand you, man. Like, let's move on to the next. He was right, though. I couldn't understand him either. He was low-key valid because I couldn't understand the guy. He kind of did that face. He's like, I can't understand him. He said, how's everything going? They getting ready to come back from break. And we're hoping John Lewin is up next. And somebody said his ego, Simply Lee says ego won't allow him not to have the last laugh. Yeah, his accent was thick. His accent was thick. I couldn't understand him. And it was this Indian guy in the comment section. He said, I'm from India and I can't understand him. He said that. He said he said something. Did you think about the terrorists? Do you think about this and that? He said, what? And like, I can't understand you, man. It's just the way he said it, but he was valid though. He was. That's why people were like, okay, he was valid. He was. But the fact that he can say that though, like he just say what's on his mind, like for real. He said the Indian promise that make India great again. India has the most people now on the planet. They beat out China. They got 1 billion people there. They got a lot of people in India, man. Y'all better hurry up and go visit the Taj Mahal before it be no more. Eventually, it ain't gonna be no more. Unless the engineers have found a way to fix it. Crazy thing is about the Taj Mahal. Did you know there's a slight leak in it, and they can't find it? And the person that the architect, he did that for some reason. I'm not sure the reason behind it. My Indian friend told me that. He said when it rained, there's a slight leak, and they can't find it. And he made it a certain way so it'll leak. And for years they tried to find the leak and they can't find it. I don't know where it's at. So he was kind of a genius in that way of creating it so it'll leak somehow. But it needs some repair. Maybe they are repairing it. I'm not sure. Repairing the structure because they said it's going to just straight up fall eventually. But I don't know. See, there's a delay right now, so I don't know what John Lewin doing. There's a little slight delay right now. Maybe it's going down already. Ryan, you just in time. You say your sister went to India and she would never go back again. I know some people that happened to, Ryan. I know somebody went over there and it was somebody I had met when I was in Thailand years ago. And the thing is, because we were supposed to be a travel group back then, but I never got to travel really like that. You know how you start working and working and working and you get on the grind and you just don't have no time to travel. I be thinking about that. I wasted so many years, yo. And I wanted to be traveling the world, yo. So I was like, that's what I'm about to do. When they get this plane situation together, I'm scared of these planes right now. I think what I'm gonna have to do is if I get on a plane, I'm just gonna say, fuck it, man. Just, make peace with God, man. I'm getting on the plane. And that's it. And just go to One time, I was going to Florida. I slept the whole flight. The whole flight I slept. When I woke up, the flight attendant shook me. She said, it's time to get off. I said, we just got on. She said, you was asleep the whole flight. I said, was I snoring? She said, no. She said, you were leaning in such a way. We were worried about you, the way you were leaning. I said, ain't nobody, I said, you could have said something. She said, no, you were in a good sleep. He said, the Taj Mahal is one of the wonders of the world. It is. All right.
Norman, are you ready?
Yes, thank you, Your Honor.
Floor is yours.
Thank you. Good afternoon, everybody.
Uh-oh.
Over lunch, I had a nightmare that when I was gonna come back up here, that Mr. Tacopina was only half done. I think, I'm not sure, but I believe I had a birthday and at least one grandchild during that closing. And I bring that up for a specific reason, and that is, do not confuse the length of that argument with the persuasiveness of it. What we kind of have gotten away from is why we're here. So this is a case of People versus Rakeem Ayers. This is not People versus Mr. Efron. It's not People versus John Lewin. It's People versus Rakeem Ayers. And the reason that I point that out is because if you didn't know better and you listened to the closing, you would think that either Relly was on trial, maybe I was on trial, and we're not on trial. And I think it's important when you are listening and really going through these arguments that you understand what this case is about. And for that reason, I'd love to say that I'm going to be very brief up here. And the reason I'm not going to be is that, unfortunately, I've got an obligation to make sure that I address the points that defense counsel made. Whether those points are relevant, whether those points are persuasive. I can tell you this, I won't be as long as Mr. Tacopina was, and I'm confident that you will get the case today, this afternoon. But that's where we are. I want to start with, this is Randy's Donuts. This is Randy's Donuts. This is on the corner. You're looking at Randy's. This is in Inglewood, on the corner of basically Florence and, Manchester and La Cienega. This is the exit from the 405. If you're coming, we're looking northbound. And 30 years ago, when I was a young deputy DA in Torrance, I used to drive from home, and I would have to take this route on the 405. And I would, every day, I would get off on the 405, and I would tell myself that if God wanted me to get a donut, he would make sure that the light that you can't see right here was red. As you can see, God wanted me to have a lot of donuts. I ended up, most of the time, I stopped. But there came a time where it just wasn't good enough for me to take the chance on the light. So what I would do is, it's a really long straightaway, and you can see when you're getting off the freeway, you can see that light. So what I would do is literally, I would coast my car at 20 or 25 miles an hour, making sure that I hit the red, and then I could go in and I'd get that donut. And I bring this up because passing up that donut was extremely difficult for me. Very, very hard. And most days I wasn't able to do it. And I always thought that that's probably one of the hardest things that I would have to do. And then I became a trial lawyer. Then I started trying cases. Then I started trying serious cases. And I can tell you that what it takes to pass up that donut is nothing compared to what it's like when I have to sit here during a closing argument, and the defense is up, and I have to listen. And I want to get up and I want to scream, I want to yell. I can't do it. I try to do different things, try to focus on something else, try to go to a little happy place. It's really, really hard. It's especially hard when, as in this case, Mr. Tacopina makes an argument, and I want to be clear about something. I'm going to attack the arguments that Mr. Tacopina made, because that's what lawyers do, that's what's fair. I'm going to attack the arguments that he made. I'm going to attack the case that the defense put on. I'm not going to attack Mr. Tacopina personally. I'm not going to cast aspersions on evidence that he put on. In the end, witnesses, we don't vouch for our witnesses, ladies and gentlemen. What that means is that we put on witnesses, and those witnesses testify to what they're going to testify to. So I'm going to go through, and I'm going to very critically point out what this case is about and what it isn't about. And kind of before I get there, I want to talk a little bit about your role as jurors. So you 16 people, we started in what year? And I know many of you, probably most of you, all of you, none of you wanted to be here. Okay? And I get it. It's understandable. But you were chosen. It wasn't simply magic that you ended up as jurors. Both sides chose you. And honestly, and one of the few things Mr. Tacopina and I probably agree on is that in our country, it's an incredible honor to be able to be a juror, because in other countries, we don't have jury trials. We don't have any system of justice. But you were selected, and it literally is an honor. But along with that honor comes a duty and a responsibility. And I'm not going to understate it. I'm not going to pretend it's anything other than it's not. I will tell you, Mr. Posletic and I, we have done our duty, our responsibility in putting on this case. We have given you a case where we have proven it beyond a reasonable doubt. It's going to end up going into your hands, and I'm going to explain to you what the evidence demonstrates and what the verdict in the case should be. Some of you might be saying, wait a minute, I don't understand why we had a trial. Because let's face it, no matter how much the defense wants to talk about how this is all about Relly's credibility, it isn't. It's on video. What's amazing about this case is how little in the end Relly's credibility for anything that matters in the case is really an issue. Now, it certainly could have been an issue. There could have been a defense in this case. There could have been, where the defense put on evidence and they said, hey, listen, Relly, you can't see it, but Relly, when he came, had a weapon. And he said, I'm going to kill you. And the defendant at that point in time pulled a gun to defend himself. And the situation ended and Relly followed. And he threatened again, and he pulled out another gun. And that would have been difficult for us to counter, not because it's true, but because the evidence that you would have been given would have been much more problematic, much more difficult. That's not the defense they chose. The defense they chose, and I'm going to get into this in a little more time and more detail, but I want to make sure you all understand it right off the bat. This case comes down to one issue and one issue only. They are saying it's a prop gun. If it's a prop gun, he is absolutely not guilty of the charges. Not because he didn't pull it, not because he didn't fire it, but because under the law, if it's not a real firearm, it's not a violation of Penal Code Section 245, and it's not the personal use of a firearm. Now, here's what's interesting. Now, again, I'm gonna explain this in more detail. Ms. Tacopina got up here and he says, absolutely, hey, listen, he did not have a real gun, it's a prop gun. But it's still self-defense. That's not true. If it is a prop gun, there is no self-defense. And the only way you can get to self-defense in this case is you have to find, one, that it was a real gun, which it clearly was a real gun, there's no question there. It was a real gun. The prop gun is a figment of the defense and the witnesses who testified to it. You have to find that not only is it a real gun and that it was fired, but that the defendant was defending other individuals or himself, and that the force that he used was necessary. And ladies and gentlemen, he wasn't defending anybody else. The force was not necessary. It's a sad situation, and I'm going to confront this head on. It would be easy for you all as jurors to say, wait a minute, I don't get it. This is a guy who's got everything. He has everything. He's successful. He's got a beautiful wife. He's got 2 children who were here. And some of you might be saying, gosh, you know what? Why would he risk that? And that's a very good question. It's just not a question that is for you to consider. Because in the end, the issue is not why did he risk it? Why did he do what he did? Because what the evidence shows is that is what he did. This is also not, let me repeat, not about Relly and his civil suit. And let's talk about that for a moment. And let's talk about exactly what we are dealing with here. I want to move forward here. As I'm talking, again, some of you might say, hey, listen, Mr. Lewin, we've been listening to this case. Why are you even up here arguing? We get it. If I were in charge of the court system, which I'm not, I would make an adjustment. And what would happen is there would be a scoreboard right on top of between where juror number 4 and juror number 5 is. And I could look up and I could see, okay, we're up 42-0. I can take a knee, I can run the clock out, but I don't have a scoreboard. I have no idea what you 12 jurors are thinking. I have no idea. I have no idea if some of the crazy arguments by the defense, gosh, maybe somebody believes them. One of the most difficult, frustrating things that can happen is, and I try not to do this, but I will see jurors taking notes, writing things down at certain points where I'm thinking, oh my gosh, why are they writing that? What could, that doesn't make any sense. Of course, I don't know what you're writing. I have no idea. You could be writing down a point, you could be writing down, that doesn't make any sense at all. I have no idea. But here's what I do know. I've got an obligation to make sure that I address everything that the defense has brought up. Good points, bad points, irrelevant points, nonsensical points. I have to address it all because I don't know where each one of you are at. And the reason is pretty simple. There is no way that I can ask you 12 jurors to do your job if I haven't done mine. So that's kind of the background of where we find ourselves. All right, let's talk for a second about the defense closing argument. I think it's important. So what they have done, and listen, I get it. Relly, in a lot of ways, was a very problematic victim. Why is he problematic? Well, one, in a lot of ways, he's not very sympathetic. And I'm not here to get you to like Relly, to get you to say, you know what, Relly deserves $30 million. Because unlike what Mr. Tacopina said, you're not here to decide that. You are not here. I'm not Relly's lawyer, and you're not the jury who's gonna decide what damages he's gonna get. Evidence has showed he has a civil suit. You're aware of that. I'm not telling you anything that's not a part of the evidence. And if that civil suit goes to trial, as you all know, there will be a jury that will decide what, if anything, he gets. That is not U12. I don't mean to shortchange you alternates. Being alternate is a really, I'm not gonna lie, it's a crummy job. You get to sit through everything, and then you don't get to vote. I think I said this on Bois d'Ire. I would have held my hand up and said, I cannot be an alternate. I can't do it. I need to be able to vote. So when I say U12, I really mean U16. You never know who's going to end up on our jury. But what is important to keep in mind is that you're not here representing Relly. But you know what I do want to explain? I want to explain for a second what happened with Relly and who he is and what he's been through. And I think it's really important, and this kind of goes to what the defense is in this case. This is a picture that if you look at it, it's very blurry, okay? You can't see what's going on. Why is that? Because what the defense wants to do is they want to zoom up so close on every irrelevant fact that you forget why we're even here. And what's an example, Al? I'll tell you right now. Mr. Tacopina spent time pointing out the fact that Relly was not honest about buying a property in Miami. Now you need to ask yourselves, what does his property in Miami have to do with what happened on November 6th? Nothing. But he would say, well, but wait a minute. If Relly is not being truthful about that, you don't have to believe about anything. I'm going to get to why that is not what the instructions actually direct you to do. But I want to do something more. I want to do something better. I want to explain to you from the evidence why Relly was up there doing what he did. So let's first talk about the fact that Mr. Tacopina spent a lot of time talking about, hey, the defendant, he just sat there, he was dignified, he didn't make any fuss, etc. That's all true. That doesn't mean anything. The defendant is an extremely powerful individual. His wife is even more powerful. Relly found himself in a situation where he was on the wrong side of that power divide. And by the way, it doesn't matter why he got there, but you know why. You heard it. There was a disagreement about ASAP Josh and about what happened to him and what was going to be paid for and what wasn't. And what's important is that Relly and the defendant had a disagreement about it. That's what happened. And because of that disagreement, and because of ego, this is what happened. Now, some of you might be saying to yourself, well, wait a minute. I mean, in the end, what really happened in this case? Okay, it wasn't a prop gun, obviously. The evidence demonstrates, and by the way, we don't have to prove that Relly got shot. The reasonable inference from the evidence is that he's got a wound on his hand that he didn't have beforehand. I'm going to address this again, but every time you hear the defense say, where was the witness to testify to that? You need to remember something. They are the ones that are arguing that this was a prop gun. They are the ones that are arguing that Relly didn't actually sustain these injuries from a gunshot. They are the ones arguing that casings would not have been found. You've got how many lawyers over there? How many people? There was a point in time during jury selection where they almost had a football huddle. There were like 8 or 9 of them over there. Do you think for one moment millisecond that if those individuals had something positive to say to help the defendant, that they would have called those individuals. If, for instance, Relly's injuries could not have been caused by a graze wound, they would have called a witness. So what you're left with is, Relly didn't have that wound when it started. He testified that he felt heat going through his hands instantly. So the idea that, well, it's a minor wound, and that's true. But we're not here to talk about the consequences. I want to really point out something that's really important. This was 10 p.m. on a busy Saturday night in the middle of Hollywood. And what happened? And you know this. Well, I'm going to go through this evidence at length. But the short story is that the defendant, because he was angry, because of ego, because of the fact that he is who he is, he decided that he was going to have a confrontation with Relly. That's what happened. We'll go through the video. It's very clear. The defendant goes there with a gun. He's got two guys with him. He grabs Relly. He initiated this incident. And what I don't think is being addressed enough, and Relly talked about it, is that, remember, Relly has no idea before this is happening. He doesn't think it's this severe of an issue. They've known each other half their lives. They understand they're upset with each other. That's clear. You have to text back and forth. But at that moment, and I'm not talking about when the defendant fires the gun. I'm talking about the parking garage. When the defendant pulls out the gun, Relly's entire future flashes before his eyes. And do you know what that future is? He's done. It's over. What makes it over? Well, he understands that if the defendant is upset with him enough to pull a gun on him, that he's going to ruin him. As he told you, that means no more artists will sign with him. That means record deals will go away. He's done. And he doesn't know this is coming. He doesn't have time to contemplate it. And what's his response? It's shock and it's anger. And it's not really thinking about what is smart. The argument that Mr. Tacopina makes is, well, who would go after somebody who's pulled a gun on them? Well, that's not quite a fair argument, because it's not somebody who's pulled a gun on them. It's someone that was a close friend. And Relly told you he really wasn't thinking about the consequences. He was angry. He also told you that, you know what? Rocky had pulled a gun on him and he put it back. So he realized at that point, his life as he knew it is over. By the way, he was right. So we're not here to talk about what damages Relly should get, what damages he shouldn't get. But let's remember something. That man shot him. That man took away the career that he had. I don't know what that's worth. 30 million sounds a bit excessive to me, but I'm not the lawyer in that trial and you're not the jury. So that will be hashed out, that will be debated, and that will be eventually decided upon. But there's no question in that moment, he realized that he was losing something very, very important, very precious. And so what does he do? He follows, and we have the second incident. Now, what started the second incident? We'll never know. We know that Relly is yelling at him. Relly is saying very unkind things. And we know there's no question the defendant is proud. Okay? And I'm going to give you another word because I'm not going to hide from it. He's entitled. All right? Everybody runs around. He is a big, important man, and everybody serves him. This is just a small example, but it's important. The witnesses who came in are dependent upon him financially. They're dependent upon him for their careers. And what happened in the middle of a trial with 12 on the stand? 12's asked a question. Has anyone ever seen or heard a defendant yell out to a witness in front of the jury, "Don't answer that"? That's what happens when you have a lot of power. And no one has ever told you, you know what? You can't do that. So why did the defendant, why did he take out the gun and fire those shots? I don't know. But you don't have to figure that out either. Because in the end, and I covered this in jury selection, I asked each one of you, if I prove to you, Mr. Zemek and I, if we prove to you what happened in this case, beyond a reasonable doubt, and you don't understand why it happened, it still happened. But that's not where the story ends, because that act, and the first act's important too. When he pulls the gun out, I'm gonna go through the video, but it's very clear that that incident ends because a couple of people walk by. That's very clear. There are witnesses. One of the witnesses, I think 12, I believe, even mentioned, yeah, there's people walking by, but that's not what ended. Well, you can see where they are, and you can see that right after, that's when he puts the gun back. When they get to the second scene, something happens. And one of the things that makes no sense in the defense argument, 0 sense, is that they keep talking about the timing of the shots. Okay? It's not when the first shot was fired, and you're going to see it. You can see, you can't tell what it is, but you can see Rocky make a movement behind his back and pull out a firearm. Pull out, you can't tell what it is, but he's going to pull that item out, and at that point in time, he's going to start advancing to where Relly and Ills are. That is what Relly responds to, is that firearm being pulled out. Yes, he grabs Ills before the first shot is fired because he's trying to avoid getting shot. So again, the timing of which shot it is it 1 second before or after? That's an irrelevancy. It doesn't matter. It's not even the defense theory. And the other thing that is really, really important, and again, I'm going to call it out. I'm not going to hide behind it. That man decided that his ego and his vendetta and his anger at Relly was important enough that he was going to risk not only Relly's life or Ill's life, but he was going to fire 2 shots from a 9mm firearm in the middle of Hollywood. Now, I don't have to tell you, because you all know it's common sense. Bullets travel until they hit something. That's what happens. They're fired at very, very high velocity. They're coming out at an incredible speed. And they travel until they hit something. Sometimes what they hit is the ground. And they ricochet. Sometimes what they hit is a car. Sometimes what they hit is the person they're aimed at. And sometimes some tourist walking down Hollywood Boulevard with her family all of a sudden drops dead because they've been shot in the head by a bullet that somebody selfishly fired to settle a childish dispute. That's what he did. That's the conduct in this case. It's not about what injury Relly received. It's not about how much money he's going to sue for. Those are not in the jury instructions. You're not going to see a jury instruction on, quote, extortion. Because that's not what you're here to decide. That's what happened in this case. That man decided, you know what? I'm angry. And I'm gonna show him. The defense argument, as I listened, it was almost like Mr. Tacopina took off in a plane with no flight plan. And he flew around in circles. Circle after circle after circle. And eventually, he kind of just ran out of gas and kind of just crashed the plane. There wasn't much direction. There wasn't much focus. And there wasn't an emphasis on the actual facts you're here to decide. Now listen, he's got a tough case. In opening statement, my partner got up here and he told me this is a simple case. It is a simple case. I'm going to tell you, this case could and easily could be a 5-minute verdict. And here's why. Because once you decide that this was not a prop gun, and ladies and gentlemen, it's not a prop gun. I'm going to go through all the reasons. And once you decide that, this case is done. It's over. Because that's the defense in the case. Not, as Mr. Tacopina tried to argue, well, it's self-defense. You notice, Mr. Tacopina didn't actually reach the next step. He talked about self-defense, but he never explained to you, for it to be self-defense, you have to find that it was a real gun. That's what you have to find. If you have a question about that, you ask the court. You have to find, to get to self-defense, that it was a real gun. And their defense in this case was, it was a prop gun. That's the issue in this case. Was it a prop gun or was it not? If you find it's a prop gun, all I can say is, you know what? You really need to examine why you're getting there. And I'm going to bring up something that's really important. The defendant is a celebrity. His wife's an even bigger celebrity. Many of you know who they are. They brought in 2 adorable children yesterday for closing argument. Now, they haven't been here at any other time. And you have to ask yourselves, those kids have a right to be here. Why children that age would be here in a situation like this, don't know. But you have to ask yourselves, am I going to let my feelings of not wanting to convict the defendant? And Mr. Tacopina made it very clear. If you notice in closing today, he literally brought up Rihanna, he brought up the defendant's family, and he basically was saying, hey, listen, if you convict him, it's going to be very difficult on the family. That is not something you are allowed to consider. So I'm not telling you I don't think you should consider it. You are not allowed to consider it. If you think you are allowed to consider it, ask the question of the judge. When you go back, you can send out notes, you can ask questions. You are not allowed to consider how this might affect Rihanna or his kids. And there's a very simple reason. We are all in the world responsible for what we do. And I'm going to add something else too. There was testimony from ASAP Lou. And ASAP Lou, even though it wasn't a question, ASAP Lou wanted to get in front of you, I think 2 times at a minimum, that the defendant is looking at 24 years in prison. The defendant is looking at whatever Judge Arnold decides he's going to give him. So you are not allowed, by the way, to consider, oh my gosh, if I convict, you can get 24 years. You're not allowed to consider, even if that was true. But in the end, Judge Arnold will decide what the sentence in this case is. So if any of you go back there and say, well, you know what, I just don't think that this crime, I'm just not comfortable with 24 years, you can't do that. If one of the rest of you does it, guys, it's misconduct. You can't do it. You gotta stop yourself, you gotta stop the person next, and you gotta say, you know what? We can't do that. All right, you've gotta base your decision on this case on the facts that have been proved from the evidence. Now, this is really important. The instruction does not say on the facts that have been proved from the people's evidence. That is hugely important in this case. There is no question whatsoever that our case got immeasurably stronger because the defense chose to put on a case. No question. Even if some of you were saying to yourselves, you know what? I don't think based on just what the prosecution put on, that I would have convicted. And let's think about that for a second. Until the defense case, now they mentioned an opening, but remember, opening is not evidence. Until the defense case, we don't know what the defense is. It could have been self-defense. It could have been any number of things. It wasn't. They chose to put on a defense. They didn't have to. You remembered one year I asked you all, are you going to give any points to the defense if they choose to put on their defense in their case when they don't have to? Or are you going to look at their evidence as critically, as importantly as you do for our evidence? You all said you would do it. They elected to put on a defense that killed their case. It destroyed it. And I'll go through it. It started with Wally. The best evidence from the victim, this is probably the second thing I agree with Mr. Tacopina. Mr. Tacopina put on Wally to impeach the defendant, to impeach the victim on an issue of whether it was his voice. And obviously, it was Relly's voice. And obviously, he was uncooperative. But let's take a step back and ask ourselves, why was Relly uncooperative in this case? Relly told you, and you saw evidence of it, in April of 2022, when it came out that Relly was the individual who reported the defendant to the police, he's facing death threats. His family is facing death threats. So he is up there not wanting to answer any question about his family. He doesn't even want to give his girlfriend's name. He doesn't want to say where he lives. He doesn't want to identify anything about Miami. You got to ask yourselves, first of all, is it understandable why he didn't want to answer those questions? Of course it is. You have to ask yourselves, Mr. Tacopina repeatedly asked those questions. Listen, that's his right as a lawyer. He can certainly do that. But it was very clear that the result of that, if not the intention, was to get Relly upset, to get him agitated, and to shut him down. And that's what happened. But even more importantly, none of those questions, none of those answers matter. And what's amazing is the defense, their witness, they put on the evidence from Wally, which is some of the most crucial evidence in the case. And again, I'm going to get there. So the defense had no obligation to put on a case. They could have done nothing. But do not be mistaken. Some jurors go back and they say, you know what? Well, because if I only look at the people's case, they haven't proven it beyond a reasonable doubt. That's why this says prove from the evidence, not prove from the people's evidence, all of the evidence in the case. So we've got a duty, and we don't hide behind it at all. We have a duty to prove the defendant guilty beyond a reasonable doubt. And by the way, it's interesting. Ms. Tacopina keeps talking about, quote, reasonable doubts. There's no such thing as reasonable doubts. They are not individual pieces. Reasonable doubt is an overall view from all of the evidence. So when he says, well, listen, if you have a reasonable doubt about Relly's credibility, then that means it's a not guilty. That's not true at all. The question is, when you look at all of the evidence, if you find that Relly's credibility is really material, if you find that there isn't other evidence that overcomes it, does the overall collection of the evidence cause you to have a reasonable doubt? There is no such thing as reasonable doubts. They are not like pieces of a cookie where you pick up one and go, here's a reasonable doubt. Here, it's not how it works. And you got the instruction that shows it. We have to prove every element of the crime charged. No question, that's our burden. But this is really important. Not every element in every case is in dispute or reasonably in dispute. So what does that mean? So for instance, we would have had to prove that it was the defendant who was at the scene. That's our burden. But the defense has already conceded that. We would have had to prove that the defendant had a gun. They've already conceded he had a gun. They say it's prop gun. We would have had to concede, we would have had to prove, that the defendant assaulted Relly with the gun. Well, they've conceded that. They just say it was a prop gun. We don't have to prove whatsoever that the defendant shot Relly, although that's what the evidence demonstrates. So very little in this case is in dispute, and that is hugely important. So let's talk about the relevant evidence in this case. So the day before the shooting, November 5th, 2021, Relly's in a car with Jabari. Again, I gotta talk about Bari for a second, ASAP Bari. The defense is saying, well, why didn't you bring Bari in to us? Bari is the guy, if you remember, who posted, who is calling Relly a rat or a snitch. I can't remember which it is right now. The people's position is that Bari is not credible. If the defense wanted to bring him in, if they thought that he had evidence to add to their case, they would have brought him in. They flew in a guy from France, okay? Let's just take a step back. They flew in an individual from France at tremendous expense on almost no notice. And they flew him in because they wanted to prove that that was Relly's voice on the tape. Now, one has to ask themselves, do they listen to the tapes? Because the tapes are some of the best evidence we have in this case. And you know that they only played for you a little snippet. I'm going to play the whole first part of that call, uninterrupted. I'm not going to give a snippet. So what happened in this case? Day before the shooting, there's an issue between the two of them. Okay? The defendant is upset with Relly. That's not a dispute. He's upset with him. I have no idea whether Relly was right about this dispute or the defendant was right about the dispute. But here's what I know for sure. It does not matter. It's not an issue for you to even consider. If let's assume that Relly paid for every part of ASAP Josh's funeral. Okay? The most expensive funeral in the history of mankind. He paid $20 million for the funeral. Let's assume that happened. It doesn't change the fact that he can't assault him with a firearm. I don't know. We have no idea who was right on this. But it's very clear it doesn't matter. But what's important is there is a dispute. And by the way, if that call did not take place, do you believe for a second that they would not have brought ASAP Bari in? And what do you think would have been the response for the defense if we would have brought ASAP Bari in, and ASAP Bari would have lied the same way that Welby lied, and Wally lied, and ASAP Lou lied? So he's his close friend. If that guy was going to help him, they would have called him. And they have the power of the subpoena just like we do. And in fact, he's the defendant's friend. They know where he is. They're able to access him. So the fact that he's not here, do not get caught up in that game. But, again, The relevance of this is simply that they had a dispute the day before. And the defendant, who is clearly a proud individual, got embarrassed by the fact that Relly is hearing him talking about him behind his back, which, let's face it, it's not very manly, okay? It's just not. And it's clear that the defendant is embarrassed by this. He's embarrassed by the fact that Relly knows he is talking about him behind his back. And Relly doesn't like it, clearly. So this is the day before the shooting. You can see what's going on. I'm not going to repeat the language. This is what we have. And by the way, at this point in time, this is a stupid little incident, okay? The man's a multi-millionaire. Why on earth is he going to take it to the level that he took it? I don't know, but that's exactly what he did. So what happens? Well, the day of the shooting, we know that Relly is receiving a bunch of calls from the defendant, from Ills, and from Twelby. And if you don't think that Ills and Twelby know what's going on, I got a bridge to sell you, okay? If you think, as the defense argued, that those were credible witnesses, Relly was angry and he was hostile. They weren't angry or hostile. They were just liars. Start to finish. So what happens? Well, we know shortly before the shooting, let's get to it, stop ducking my calls. Now, by the way, Relly says, hey, listen, I'm not really sure what's going to happen. And when you look at it, it looks like they're going to have a disagreement. But this is really important. Relly can kick the defendant's ass all day, okay? That's clear. But if Relly does that, he loses his life. He doesn't have any interest in doing that. He knows it, the defendant knows it, everybody knows it. Even those lying witnesses, Twelby and Lou, eventually had to concede that the defendant has a lot of power in the industry. The industry where Relly works, the industry that he is dependent upon for his livelihood. So he's got not only no motivation for getting into a fight with the defendant, he can't do it. He's got to sit back and take whatever he's going to take because he's power. That's who he is. He's got power. There's Rocky and there's Relly. Rocky knows it and Relly knows it. That's just the facts of life. So what happens? We have this incident. Now, thank God we have video in this case. Okay? Because without video, we'd all be in trouble. This video is very clear. And when Relly is walking, there's a couple things you want to consider. I'm going to get to this again. The idea that the defendant is bringing a gun to this meeting makes no sense at all. He's got two guys with him. He's not afraid of Relly. Relly's not looking for a fight. And you're going to see that the first action is the defendant grabbing Relly. That's what you're going to see as they're walking up. And I have this is slowed down so you can see. So what you saw, the defendant grabs his arm. Now the defendant is pushing him forward. Relly is holding him back. Now this is really important. Stop it for a minute, please. Do you mind stopping it for a minute? So this is really important. Some stuff in the trial is almost funny. I would ask Twelby, so what was the weather like of that night? Man, it's cold. Man, Relly, he's huge. He's got muscles all over his body. They made Relly out to be the Hulk. They made that happen because that's the narrative they wanted to create. But the problem is Problem is, if you watch, Relly clearly is stronger than Rocky is. He's stronger than Ills is. Yet he's letting Rocky push him back. If he had wanted to, he had his hand available to punch Rocky. He didn't do it. Probably not because he didn't want to, because he's a grown man who understands that if he does that, it's over. He's got no career. He's done. What he doesn't understand is that in the next moment, Rocky's going to take out a gun, and Relly is going to realize, oh my God, it's over anyway. Please go ahead. Stop it. Stop. I don't know if you remember, but when I had Toby on cross-examination, and he is saying that he's trying to pull the Relly off of Rocky. And I think this same image, and I'm asking him, well, wait a minute, how are you trying to pull Relly off of Rocky when you're in the middle? You're trying to keep Rocky off of Relly. No, I'm not in the middle. Of course he's in the middle. Keep playing it. And now watch the gun. Stop. It is true, we do not see the gun come out. But we know from before that the gun was not in Rocky's hand because we saw his hand before. Now, if you remember, what was Twelvy's version of how the gun came out? I mean, guys, I'm not making this up. He said that Relly lifts Rocky off the ground. His pants fall down, and Relly reaches back to pull his pants up and happens to end up with the gun and what looks like his finger on the trigger. That is more absurd than, again, the tornado example with Bill. It's absurd. It insults your intelligence. And the only value that it has is if you are going to try to find a way to let this man get away with what he's done. And this goes back to what your duty is. You're here to call balls and strikes. What happens to Rocky is not your responsibility. Not whatsoever. Your responsibility is determining what happened. It's almost like what an umpire does, okay? When an umpire calls a strike or calls a ball, he doesn't own what happens in the game. The players decide the game. He's just making the calls according to the rules. Do not be fooled into the idea that, quote, Rocky's life is in your hands. Rocky's life is not in your hands. The determination of what Rocky did is. And what happens from there, that's on him, and that's up to the judge. So what happens? So he's got the gun out. Continue to play, please. Stop. So if he was trying to put the gun back, why is the gun now from behind him to in front of him? So they're going to say, well, you don't see what he does with the gun. Well, if his gun fell out accidentally, why doesn't he put it back? Well, it's because it didn't fall out accidentally. He pulled it out, and now he's going to assault Relly with it. And the fact that you don't see the assault because of the cameras, ask yourselves, logically, he took the gun out. He switched hands. The gun is now in front of him. What's he doing with the gun? He's doing exactly what Relly said he was doing with it. And by the way, nobody said that the defendant tried to murder Relly, intended to murder Relly. You're not charged with that. So the gun comes out. Continue to play. Stop. Okay, now if you notice, he's about to put the gun back, and you're gonna see the people crossing because, keep playing. So the gun went back because you see the people that are on top? They are walking from the direction where Rocky just was. Now, why Rocky put that gun away, we're never gonna know. I can't prove to you beyond a reasonable doubt why he put the gun away. No one can. I can tell you that the evidence suggests, clearly, it's undisputed, there's a couple of people walking right by. It's in the middle of Hollywood, and Rock's a pretty famous person, and if he was planning on shooting the gun at that point in time, that would really seem to be an ill-advised place to do it. You have to ask yourself, do you think it's a coincidence that when Rocky ends up actually shooting the gun, that the gun is shot in a place where Rocky reasonably doesn't believe anybody's watching him? He doesn't know about the cameras. He knows there's a crowd of people here. Jimmy, please. So this is how the first incident ends. Okay, this is how it ends. So when we're looking at this, that's count one. That's the assault with a firearm. That's the personal use of the firearm. We don't have to prove any more than what you've just seen. Now, we do have to prove that it's a real gun. And here's what's interesting. Why are we unable to determine definitively? We certainly have strong evidence that it's a real gun based on what happens in the next scene. But who was in control of that gun? And let's think about what the argument is. They're saying that's a prop gun. Where's the prop gun? How are we supposed to prove that it's not a prop gun when they've got the gun and they got rid of it? It's impossible. There's no way for us to do anything more than what we've done. So what happens at the next scene? Part two of this. Now this is going to be important because what you're going to see here is you're going to see that the incident starts before Relly ever grabs Ills. By the way, Ills is the guy he likes. He doesn't like 12. So you want to just ask yourself for a second. He never tells anybody, hey, Ills had a gun, Ills had a knife. Here's why I assaulted Ills. He's not assaulting Ills. He's not punching. He's not doing anything to Ills. He's using Ills as a shield, just like he's going to say. But let's look up to the top left corner what's going to happen. Oh, no, okay. So here we go. Back it up again. Start this one over. So when you're watching this, what you're going to see is not as the defense described, that Relly grabs Ills and then Rocky defends him. What you're going to see is Rocky is going to reach behind and then he's going to advance towards Relly. That is clearly when Relly sees the firearm, and that's when he ends up grabbing Ills. So the idea that, well, the gunshot doesn't happen until after he grabs Ills. It doesn't matter. Relly's responding to the fact that Rocky's pulled a gun on him for the second time. And by the way, this is a lot scarier than the first time. Because now they're by themselves, and clearly Relly is concerned he's about to get shot. Now, I'm going to get to it, I'm going to address it, but this doesn't even begin to cover the idea that their defense is not just this was a prop gun, which is absurd. It's an absurd defense. Their defense is it's a prop gun, and Relly knew it was a prop gun. And even though Relly knew it was a prop gun, Rocky pulled it on him to scare him, even though by their own admission, he knows it's fake. And you can see Relly running around, and you can see what 12 does, and you can see what Rocky does, and no one is acting like it's a prop gun because it isn't. So let's watch it. Boom, guns out. By the way, at one point in time, one of the witnesses, I think it was 12, he said that the defendant fired a warning shot. You don't fire a warning shot with a prop gun, it doesn't fire anything. Also, you can see that on that shot, the defendant has the gun out, facing forward, appearing to target Relly. And by the way, he moves into a better position in between the shots. And the only reasonable conclusion you can reach from that is that he is trying to get a line of fire onto Relly. Relly didn't suffer the minor injury because the defendant didn't try to shoot him. He suffered the minor injury because he used Ills as a shield, and for whatever reason, the defendant didn't hit him. At least didn't hit him other than in his hand. But the idea that you need to look at the gunshot and the fact that Relly is already grabbing Ills as a shield, that's just misleading. It just doesn't work. I'm going to play this now in half speed. Let us give you a second. And the idea, by the way, that Ills, that 12E is running away because Relly is trying to attack him is absurd. If you knew nothing, all you saw was this video and somebody told you, hey, listen, that's a fake gun, and everybody knows it's a fake gun, you would go, well, wait a minute. If it's a fake gun, why is everybody running around? Why is Relly grabbing Ills as a shield? Why is 12E running away? By the way, how does this incident end? This incident ends not because the defendant voluntarily says it's over. 12E literally is blocking him and pushing him away. The defendant is fired up. He's angry. We don't know what was going to happen next, but it's not as if the defendant decided on his own, you know what, I'm done. 12E pushes him away. So this is the close-up. And again, this is a little bit harder. This needs to be played at half speed. I got it. This needs to be played at half speed. Again, we already know that we've got. By the way, the only thing that Mr. Tacopina did not accuse Relly of was planting the nail on the seat. And I was waiting for it. I was waiting for him to say, Relly planted the nail. He was trying to get me. So we know who we have, defendant, 12E, and we've got, which is hard to see, we've got Relly and Ills. So what happens? You watch for yourself. You're going to see Relly reach and then move. When Relly reaches and moves, when the defendant reaches and moves, that's when the gun is out. Whoops. Sorry. So here we go. Boom. You see him reach, guns out. 12E moves. Relly is running, trying to get behind Ills. He's not beating Ills. And what is Rocky doing? He's running around, trying to get a shot, and he's going to fire. And when he fires a second time, the gun is outstretched, aiming at Relly. And now look, there's 12E grabbing him and making the defendant go away. That's how this thing ends. Again, and I understand it. You guys don't want to believe that this man who has everything, is going to give it all up for this. I get it. But that's a decision he made. I didn't make it for him. You didn't make it for him. The judge didn't. Mr. Tacopina didn't. He made that decision on November 6th. And what's crazy is that apparently Relly would have been more than willing to take the money and not cooperate with anybody. And by the way, why is that? do you think that if you are in the hip hop rap community, that going to the police and filing a case against ASAP Rocky is gonna help your career? It's done. When Rocky was saying, and you heard it before, hey, I'd be on the beach, he would have been on the beach. So not only did the defendant commit this violent crime, but in the end, his attitude was, no, I'm not giving you anything. Now, that's arrogant, but it's what happened. And I want to make sure that no matter how successful he is, how famous his wife is, how cute his kids are, how much they giggle here during closing arguments, that you guys are not going to say, you know what? We're going to give him a little extra. He needs to be treated like you would treat any other person. Because in the end, that's all that he is entitled to. He doesn't get to be the big celebrity in a jury trial. He's a defendant like anyone else. Okay, so what happens after the shooting? Immediately, Relly understands what's going on. So we had, this was very interesting. We had the officers called, and the whole idea is, we know that this incident never happened, meaning it was only a fake gun because they didn't find the casings. And what became very clear, ladies and gentlemen, is the defense did not realize until we called our witness, started questioning Lou Levin. They did not realize, it turns out that the prop gun, which was apparently a 9mm prop gun using 9mm ammunition, prop ammunition, is going to have the same brass, maybe lighter, but it's going to eject the casing the same way a real 9mm does, because as Lou Levin told you, and I think as 12 told you, who knows less about guns, the point of those prop guns is they're supposed to look realistic. And if they don't eject the casing, they're not realistic. And any of you who've ever seen a firearm, any semi-automatic firearm, understands that in order for a second shot to be fired, unless you're going to manually take a round out and put it in, which you don't do in a semi-automatic, it's got a chamber and cycle around. That's what it does. They didn't realize that. So what happened is they spent a bunch of time talking about the incredible investigation that the LAPD officer did on the scene. I asked you during voir dire, are you going to be able, in this case, are you going to be able, if you don't have every question answered, to come to a verdict if the evidence demonstrates to you beyond a reasonable doubt that the case is improved? Each one of you said, no, you know what, I don't need every question answered. Let me tell you a question we can't answer. I cannot tell you why LAPD did not find the casings that night. Don't know. They certainly looked. But here's what we know. They didn't find any casings, meaning if the defendant's position is correct, if the defense position was the prop gun is correct, there should have been casings there for the prop gun. They weren't. And what we know is Relly went back and he found them. And I'm going to go through and explain to you why that's credible evidence. So what happens? He goes back, he texts and he says, hey, you tried to kill me. Okay? What are you talking about? Why are you telling people I shot at you? That's what the defendant says. By the way, the defendant's position now, their defense is that he shot at him, it was just a prop gun. So the question isn't that the defendant is lying here. I mean, clearly he's lying. He's just saying, oh no, it's prop gun. So, Relly says, you tried to set me up and take me from my daughter. He is saying, you tried to kill me. That night, in that text. Relly doesn't know we're going to trial. And what's the defendant's response? Not, hey, that was a prop gun. It's stop making shit up. So, this is what they say is the big evidence in this case. Yes, Relly decided that rather than cooperating with the police, he was gonna try to get a bunch of money. Is that the honorable thing to do? Is that the good civic-minded thing to do? Of course not. Because the defendant firing his gun in the middle of Hollywood jeopardized everybody. It's not just a crime against Relly, it's a crime against us all. But Relly didn't care about that. And by the way, eventually, when there's a civil trial, I'm sure that the civil lawyers will be arguing that Relly doesn't deserve anything. And luckily, that's not my job. We don't represent Relly. We represent the people of the state of California. And we're here because the defendant committed a violent crime. We're not here asking for money for him. And I'm not gonna sit up here and tell you what he deserves. I have no idea. So, what's important here is he's explaining in this text that he wants to get the money, but he's explaining why. He shot at me. Relly never, ever, ever has been inconsistent in the fact that the defendant shot him, that he got hit. Never. Sure, was he not upfront about owning property in Miami? Some of the questions, how did you make money in 2021? Is this a picture of your girlfriend? Imagine if you are sitting here on a case that is being live streamed. You got the camera here. You've already been threatened. Your family's been threatened. Your daughter's been threatened. Your girlfriend's been threatened. And now someone is going to ask the defense attorney, what's your girlfriend's name? Let me show you a picture of her for the world to see. What do you expect Relly to do? Okay, now we're going to get to the most important statement that Relly gives in this case. And let me tell you why it's so important. And again, some of you might be asking yourselves, why did the defense bring in this evidence? And let's be clear. When the defense says, well, we only brought Wally out here to testify to one thing, that's true. They easily could have played the call. There's no magic form where we got to play and they don't. They're arguing that Relly is inconsistent.
The objection could not play that whole ball.
I couldn't hear you. What was around?
The entire call.
We played.
By the defense.
Oh, no, that's what I'm saying. The defense could have played the entire call. They didn't.
That was the objection.
But objection sustained, go on a second.
So we decided that we were going to play the entire call. And you can listen to this call. And let me tell you what's so important about the call. Relly does not have any idea that he is being recorded. He's not talking to cops. He's not talking to a prosecutor. He's talking to someone who he thinks is his friend. Now, that person isn't actually his friend. That person is an agent of Rocky. How do we know he's an agent of Rocky? Well, we know it for a couple of reasons. One, and again, this is how just lack of credibility filled Wally's testimony. Wally says that basically he just happened to record him. And when I'm asking, wait, why are you recording him? Well, he had like 10 missed calls from me. Wait a minute, so your friend, you have 10 missed calls, you decide I'm going to record this call. He recorded him because he was trying to get information to help Rocky. And you know that because what does he admit that he did right afterwards? He calls Rocky and tells him what he said. But here's what's incredible. When you listen, I'm going to play it. Wally's testimony was he knew nothing about this incident before this phone call. Yet, you're going to hear him say, I'm not here to pick sides. So that's a straight lie. Of course he knew about it. He's Rocky's good friend. It's already been in the media. It's been blown up in hip-hop websites. Of course he knows about it. And when you listen, what is so crucial about this statement is this is Relly live, not in a courtroom, not to a police officer, to a friend, where he's got no motive to make up anything, where he's explaining what happened. And he is literally incredulous. When you listen to this, what's going on is Wally is trying to get him to try to settle this thing for money. That's what's going on when you listen. And Relly's like, hey, I tried to settle it for money. He didn't want to do it. But in terms of the facts of what happened, he is crystal clear and consistent about everything that matters. So listen.
Yo, bro. Yo. Shit, bro, say my bad. I don't know my girl and shit in bed, so you know. What happened, Rose? You know I'm not trying to pick sides and I'm mad at both y'all niggas for letting that shit happen, you feel me? Oh, it ain't no picking sides. That nigga 100% crazy and wrong. Yeah. 100% wrong. And he got 12-year ills mixed, bro. I'm not, you gotta understand, Rocky been on his high horse for a very long time, you feel me? He didn't have to do what he did. I don't have, he forced my hand, you feel me? I got over 20 missed calls between him ills. Why is Rocky going out his way to do anything like that? You get what I'm saying? I'm pretty sure you didn't hear the story or whatever it is. But you gotta look at it like this. Why is he going out his way to call me 20 times? Got ills and 12 with him. Text messages saying link up, where you at? And all of this is because of I pressed him about Josh, him not doing right by Josh, and he spoke to Josh's mom and lied. You get what I'm saying? So I wrote him about that. He hits up Bari later about that, but I'm with Bari. Bari got the phone on speaker. You get what I'm saying? This shit didn't fit well with me. So Rocky talks about me within that conversation because he sees I text him about Josh. You feel me? And told him taking ASAP out my name. This was 7 months ago. I took ASAP out my name. You feel me? Yeah. He's a bitch, so he goes in and hit Bari because Bari influenced her a whole week later doing that complex con shit. You feel what I'm saying? Just so happened I'm with Bari while Rocky hits her. Rocky says my name. You get what I'm saying? Real Money, 12-year ills is at his house. I hit Real Money the next morning, tell Real Money. I heard Rocky bitch ass tell him I don't fuck with him. Whoopty woo, whoopty woo, whoopty woo. You feel me? No fighting words, none of that. Just basically, nigga, I heard you. But in Rocky's head, he was like a bitch because Bari had him on speaker. Rocky don't know who else heard that conversation, but he know I heard him talk about me. And I told Rocky over the years, nigga, if you have a problem with me, let me know. Stop rocking me to sleep. You feel me? Boom, boom. Next thing you know, I guess that was enough for him. He felt like a bitch because he knew I heard that conversation. I wasn't supposed to hear that conversation because Rocky I never heard him say curse words or even have that type of energy towards me. You know what I'm saying? So now I know the real him. I tell Real Money, tell that nigga fuck him. You feel me? Boom, boom, boom. Shit gets related to him. Next thing you know, I get over 20, 30 missed calls between him, Ills, and Rocky. Text messages. I'm staying at the Lowe's. I tell him he calls me. I finally answer because I'm sleeping. Yeah. I answered. He's like, where you at? With a slip voice. I'm like, huh? Where you at? Nigga, I'm at the W. I'm not really at the Lowe's. You feel me? You know, Hollywood Boulevard, they all look the same. You're like, no, you're not. Nigga, that's a bum-ass hotel. I'm like, huh? He said, show me outside. Okay? All of it look the same. I showed him outside. What he does, be there in 5 minutes. I'm like, all right. My girl like, what the fuck is going on? I'm like, I don't know. Yeah. He calls me. Those calls me. Yeah, I got all these text messages, bro. You niggas is dumb. You and a couple only people heard this story. Rocky out here thinking it's all sweet, but his life is really, and bro, that's what I wanted to ask you, bro. Like, why boys though? You feel me? Why take it to you know the guys? You feel me? Who, me? Yeah, think on how the boys. Why wouldn't I, bro? He's a multi-millionaire. He blamed at me. I'm no longer on his level. Everybody turned on me. Everybody, bro. Rocky had everybody turn on me that day. Plus, what the fuck am I doing? Spin on his block and go shoot him up? Or do I cripple him? Because he's a multi-level bro. I'm not having nobody shoot at me where I'm taking him on the chin. And two, I'm not about to spin on Rocky's block. I'm already a millionaire, nigga. You get what I'm saying?
So what you looking for? You think
You're a black nigga. I'm teaching niggas everything how to get money, how to do this. Do Rocky do that? Do you have a foundation for black people? Do you have a foundation for anybody? No, this nigga's greedy. You get what I'm saying? So I can't sit here and be like, oh, how do you meet somebody like that, bro? You take away what they have, dogs. You feel what I'm saying? I'm not doing it on something like this, that, and the third, or some pokey shit. Nigga, I would have had a guy a lawyer the same day because he weird at me 4 or 5 times. I had to use ills as a shield or I'd be dead.
I feel niggas ain't trying to like, you feel me? You not trying to end squash this shit, get some paper or something or what, you know? Like,
bro, it's too late. He told me suck a dick. Boom, boom, boom. I hit up John the same day. Bro, that's all on him. He had nothing but time, bro. When I got the best lawyer in LA and work out my business. You feel me? He told John to stop contacting me. I sent him the picture of the bullets, sent him the text messages of him, letting him know how serious this is. You know what he said? Nigga, fuck you. So what I'm supposed to do? I accept the nigga shooting at me 4 or 5 times, but I almost died, or sue this man. Now coming with suing, of course, the severity of the case, he trying to kill me. So that's what he gotta read. You feel me?
there ain't no way niggas is squatting, like, you feel me? No paper, no nothing, bro. Like, you feel me? Like,
Bro, he's a grown, he's 33 years old. He got other things talking for him. He know what he did. You get what I'm saying? He had more than enough time. This shit happened 7 months later. He wasn't trying to reach out to me. He still didn't reach out to me.
legal shit before, not a boy, you know, so.
That's on him. I didn't even want to go about that way. I would have got a lawyer. When you get a lawyer, that has nothing to do with boys. And Jabari is his friend. He might as well thank him for him not being late in the feud because those allegations, you feel me? He got enough, and you're part of the PR team. He would have had enough people to block that if Jabari didn't say nothing, bro. Those allegations, Jabari made it official.
Yeah, so what's the next, bro?
And Jabari's getting sued too. Jabari's getting sued for defamation of character.
Cause everybody look bad, bro. You know, I'm just trying to.
He was bad. He did that, bro. I didn't call you. I didn't have a gun. He left his Hollywood house. Right? Everybody saying everybody looks bad. Why don't everybody point the finger? Because when I take, bro, I got Hollywood. I got so many people.
Niggas grew up together, bro. Niggas grew up
That's
together,
why
bro.
niggas hanging. He's in a mansion. Nigga, I paid my way around him every single time. That's him. He uses niggas. He used 12-year ills. Nigga, that was the whole joke about the whole shit with Barbie and the whole game. You know what I'm saying? The nigga asked his Barbie, he comes to the complex car, nigga, Barbie laughs at him. Like, nigga, you're not using me. Nigga, the next conversation went about how he got 12 and ills on his jet or some old shit.
Cause y'all niggas grew up together, man. Like, you feel me? Like,
I made that nigga fuck growing up. I made that nigga. I know 12, I know jams. He ain't no jams. He popped up at my crib on purple swag. I made that nigga. That's why he feel like that, bro. I've been powerful. I've been that. Jabari never did, bro. I put every last one on that.
I just want y'all niggas to kind of end this shit, you know, find out.
And he could have ended it when he shot at me. Who ends anything when a nigga shoot at you 4 or 5 times? You gotta grab another member to protect yourself. He called me out my living space. Called me, told me stop ducking him. He planned it. That's called premeditated, bro. You feel what I'm saying? He didn't give me a chance. He told me I'm gonna come down. I came to link him to see what the fuck the status was about. He pulls out. He tries to chest bump me. He tries to chest bump me and then pull out a gun for self-defense. He's a pussy boy. Jermaine Ellis is standing in between while he's trying to shoot me. He didn't give me no seconds. First thing happened like that. And I got it all on camera. You don't want that, like, trust me. You stupid. He did it all on camera, champ. So the world looking at me because of Barry's mouth right now, but in a few seconds, if I wanted to do what HBO or community did, his whole career is fucked. Everybody's looking at me like the man.
That's what I like what's your, I guess it was the end game here, bro. Like, you feel
The end game, I'm suing this shit out of him. That was my game, and regardless, I ain't don't give a fuck about no police, nigga. I'm going against a multi-millionaire that's trying to kill me.
So it's really to get in or you just trying to move on and shit.
Besides killing somebody like that, you feel me? That he gotta face the consequences of with that because he wanted to be a gangster and run out his crib like that. That has nothing to do with me. You feel me? I did my part. If you look at it on my end, what else am I supposed to do?
I mean, like, splash that shit in the streets type shit is like, man,
It ain't no street, nigga. Bro, what the fuck?
I feel,
You know who my family is? This ain't no street nigga. They ain't got 3 or 4 bodyguards, bro. Come on, don't do that.
yeah, I feel you, bro.
Don't do that. Don't do that. This man riding around with, come on. What street shit do he do, bro? This is a street nigga. You already know what would happen. Everybody know what would happen. We're talking about ASAP Rocky, bro. The face of Dior, like, come on, stop it. This ain't a street nigga.
Nah, I'm just trying to, I'm just, cause I fuck with you heavy, bro. Say, you know, I was always love every time, nigga, and I fuck with you.
I'm trying to let people know, and the ones who's close by him, this ain't no, he ain't no gangster, bro, this ain't no gangster. If this was a gangster, this would be handled in the streets.
So how niggas
They
play?
got 3 or 4 bodyguards on 24/7.
Like, what's next though, bro? Like, niggas go to court, you feel me? Like, why not just watch this
He's
shit?
finished. He's finished.
Why not just ask for the bag or, you know?
I tried already, bro. You don't ask for the bag because that's extortion, bro. When you got somebody that's shooting at you, you ever look like, I'm smart, bro. You gotta understand I'm not a dumb black nigga, bro. You know what I'm saying? You ask for a bag without a lawyer first for extortion. You feel me? You gotta do everything accordingly. Everything accordingly, or it's gonna catch up with you.
All right, folks, this time take 10 minutes. Please be outside the courtroom doors at 2:45.
What do you guys think so far? Hold on. What do you guys think so far, man, about his presentation? Presentation is something else, isn't it? It definitely is, man. He's he ain't no joke, man. He is really trying to bring this case home. It really is. He is really trying to put him away, man. That is for sure. All the way for certain. I mean, he is like, it's something, man. Like, the thing is, he's playing that conversation, right? But is there any point in that conversation where they mention a prop gun? The answer is no. And also, somebody else called him a snitch. You don't call nobody on snitch or no prop gun. That's a prop gun. There's no way this should have been a case. There's no way. There's no way that this should have been ever a case at all. If it was a prop gun, just give it to your lawyer and that's it. Then everybody go their separate ways. It was a real gun. And like I said, I know some people come in here and they say what they say. They're not trying to really convince us. It's the jury at this point. If they feel like it's a real gun, then it's a real gun. I don't want to hear nothing about no race. You know why? Because the defense helped pick the jury. Now, what you're going to say, the defense was secretly against Rocky? They helped pick the jury. Okay? They actually helped pick the jury on this case. It sure did. They helped pick the jury in this case. So it wasn't a situation to where oh man, the state was against him. Well, like I said, well, you're going to have to point to his defense then. Because I know what they're going to say if he get convicted. It was all white jury. Well, talk to his defense then. Talk to them. That's not the case here. Okay. It was no mention of a prop gun in that conversation. It don't matter what they were talking about. I'm listening for the prop gun. That's what I'm listening to if I'm the jury. I'm listening for the prop gun. There's no prop gun. Okay. This man was brazen enough. Straight bullets don't have a name to it. And I like when John Lewis said he can bring his kids in all he wants to. That don't matter. Because he didn't care about them that night, did he? No. And he said it's crazy. Out of all the time they brought him during the closing. That's for the jury to see that. I said that yesterday. So me and him on the same page. That's just so the jury could see. Nah, that's not working. He didn't think about his family that night. So if they feel like it's a real gun, he gonna have to do that. If you a man to do the crime, you gotta be the man to do the time. That's just what it is. So that ain't no prop gun. That is not a prop gun. So yeah, they can, they did the best they could. That's a good angle though. Hey, it was a prop gun. Okay, cool. Where's the prop gun? Oh, well, he sent it back to New York and now they loaned it out. They don't know where it is. Okay, well, the person that you gave it back to, bring him in for questioning. They didn't do that because it wasn't no prop gun. And that man wasn't going to try to sit up there and lie for nobody. That's why. It's over, man. Yeah, it's over. If he get found innocent, he is lucky. He lucky. And I think for my next 5 videos, I'm going to dedicate it to ASAP Rocky on how lucky he is. He need to take his scarf wearing self and go sit in the house somewhere and go sit down. You said, I don't think Relly is going to mention a prop gun in a phone conversation because he didn't know it was a prop gun. That's why. I'm talking about the other people that were calling him. Nobody mentioned a prop gun. Even when he talked to ASAP Rocky didn't mention a prop gun. He said, what you doing? What are you talking about? Like he lying. He was gaslighting him. He should have said, bro, I had a prop gun, yo. You know how easy this was for not to go to court? I don't want to hear nothing else. All he had to say was, dude, it was a prop gun, and I wasn't going to kill you. It was a prop gun. I just wanted to scare you. He didn't say that. Okay, so if he gave the prop gun back, if ASAP Blue gave the prop gun back in New York, the guy that you gave the prop gun to, even though he don't have it no more, bring him to trial and let me hear him say that. They didn't do that because it wasn't no prop gun. It wasn't no prop gun. And then they said, well, his pants was falling down. That's why no, he pulled it out. Come on, man. You see how dangerously close this is for him getting convicted? It's real. If he gets out of this, he is lucky. I don't care how he looking in court, how mean he looking. It don't matter. You weren't thinking that night. You weren't thinking about your kids, so don't bring him to court now. I love when Lewin said that. He didn't say it like that, but he kind of did. He don't give a damn. I don't give a fuck if you're a celebrity. You just like everybody else. I'm glad he said that. Because he getting his wake-up call right now. I bet you he is. In my Paul Mooney voice. Yeah, you hanging out with Yves Saint Laurent and all them people like you one of them? No, you're not. No, you're not. You getting your wake-up call, dummy. You getting your wake-up call. Sitting over here wearing scarves and kilts and shit. You getting your wake-up call now because none of them people there to defend you. You getting your wake-up call. That's right. I know somebody got killed by a straight bullet. Straight bullets don't have no name to it. Give a fuck if he's ASAP Rocky. You know what I'm saying? I don't. I am fully convinced now he had a gun. He is guilty. Guilty beyond reasonable doubt. The state right now, he didn't even finish his closing. He met his burden. He met it. They met their burden. That's my official word. They met their burden, man. They did. They met it without a gun. They met it. Right. Everybody, the defense participate in voir dire. They all do. So that jury was selected by both sides. Okay? Because I know they're gonna say, well, it was an all-white jury. No. Go ask his defense why they do that. And even if I was on it, like, okay, we got a brother on it. No. I want to know the evidence. That's what I want to know. I want to know if it was a real gun or not. Now, I heard they have a gun expert on that jury. They better hope not, because he knows it's a real gun. He's facing up. I had it right the first time. He is facing over 20 years, but the prosecutors are asking for 8. But he's facing, the judge don't have to give him 8. He can give him 20 if he wants. That's an old school judge. So he better be, shit. he better be praying right now. That's an old school. They don't play that in Los Angeles with guns and shit in California. That's a blue state. That's a blue state. They don't like guns and all that. They for gun rights out there. I mean, for taking your guns away. You know why they can't produce the real gun? Because it was a throwaway. There was also a throwaway. Also. Okay? I think that gun was a throwaway. And they got rid of the gun. And then said, well, we're just going to say it's a prop gun. That's the angle they're going with. Okay, where's the prop gun? Why come you didn't come out? How come ASAP, what's his name, didn't come out early and say, hey, yo, that was a prop gun. Rocky gave me that prop gun. He didn't want it no more. He could have easily told that to the authorities and have been over with. Because it wasn't a prop gun. They playing on people's intelligence. It wasn't a prop gun. It wasn't a prop gun, man. He is facing his issue right now. He don't got his wake-up call. You know why I say that? You know why I say he got his wake-up call? Because he thought he was important. He wasn't. You know why? They put the best prosecutor in the goddamn country on this case. They don't do that for no reason. Like, why is he on this case? He's too important to be on this goddamn case. His record is too impeccable to be on such a case like this. He's the cold case prosecutor. Why is he on this case? They want him away because they know he guilty. They want him. They had to bring the very best in. They brought the heavy hitter in on this one. They want him gone, yo. Somebody want him gone. That's why I say that. These rappers are getting that damn issue right now. Axe Puff. Their money can't save them. Money can't save them. It's a restructuring going on right now, especially in Hollywood. It's a whole restructuring going on. They don't, and I won't go out and say they don't want him. They don't want him with that billionaire wife of his, a girlfriend of his. They don't want him with her. Because if they did, they would have had protection for him. Okay, let's just do this. Let's make it so that, no, they put the very best on this case. The very best. You thought you were special? You wearing them kilts, think you cute? Nope. They want you in beige. State clothes. That's what they want you in. And they know he gonna go crazy if he's in there. They know he is. I'm telling you, man, I don't know who pissed some people off. There's somebody up top that's not playing no more. Somebody's not playing with these people no more, man. They're not playing. And they should have woke up when Weinstein got caught up. Even though he's trying to get out now. He got some action, in court, so we'll see. But when Weinstein got locked up, they should have known. These people not playing. They coming for everybody. Puff sitting up in there, probably looking like Grady now, so his hair is so gray. They don't care. They don't care about his knee, talking about his knee hurt and this and that. And no, you're going to sit right there just like everybody else because you like everybody else. I don't give a damn if you Puff Daddy. You like everybody else. Your name's Sean. You like everybody else. And that's what they're getting right now, folks. They're getting their issue. That's what they're getting. They said they knew. They said, no, this wasn't no prop gun. They knew that. Somebody up top that ain't no prop gun. Let's bring the heavy hitter on this case. And then on top of it, you know what he did? You know what he did? He was so brazen to tell somebody on the stand, don't say, in front of the jury. That's how brazen he is. Okay, we're going to see, Rocky. And you know what that guy said? He going to fuck up your Valentine's Day. He said they getting the case tonight. They're getting the case tonight. And you know what happens in California? They'll work all the way up until 7 or 8 p.m. California time. They're going to make them sit there so they can mess up his Valentine's Day. That's why he did it. He said, oh, you getting the case tonight. Sorry, I had to get into it. I'm just being extra, but yeah, I'm bringing the theatrics so I can wake everybody up. All right, here we about to go back to it.
I don't think was a problem. However, the balance of your arguments from here on out, there is to be no mention of Rihanna being in the courtroom or the kids being in the courtroom.
Just them not being in the courtroom, but I can mention, here's the problem, Your Honor. The defense got up with the court, and they talked about the impact.
Okay, you're awake. Okay, I got you back. Okay, cool.
Just don't mention them.
I'm warming y'all up for this. What's up, Abraham? Hey, Miss Lady.
Or the babies being in the courtroom. There'd be no mention of that.
Right, I'm just trying to understand, but I can mention the issue, just not talking about being in the courtroom.
Mr. Tacopina went into that.
Okay.
You're entitled to.
I was
No mention.
I was
of them
trying
being
to
in the courtroom.
report, I just wanted to understand what we were asking.
There's be no mention.
We'll do it.
All right, let's bring them to
Yeah. Try to be very, very careful.
What time do you go to?
The reason why they turn away because the jury coming in. That's why they turned away. They getting ready to get started again, but I had to warm the crowd up real quick. You said Law and Crime. They know me, actually. I know the Law and Crime Network. I remember when they first started. Yep. And now they're big now. They know that's why they don't trip too much when I use their stuff.
So that was the key evidence in this case regarding Relly. Could not have been more plain than what he said. Could not have been more credible regarding the issues that matter. And what are the issues that matter? The defendant shot him. The defendant brought a gun, a real gun, to the scene. What's interesting is that it's very clear, and you heard the testimony from Wally. Wally said he was, quote, mediating, which, please. At one point in time, what you heard him say, he changed the word, which maybe scared me. Also, I'll think of it in a second. This is what happens when you get on the board. Mitigating, thank you. Later on, he said, no, he was trying to mitigate. Sometimes that's called a gaffe. A gaffe is something that you don't mean to say, but which turns out to be true. He was trying to mitigate for Rocky. And how do you know? Because he called Rocky immediately afterward. And then he's saying, I don't remember what Rocky said. I couldn't tell you. Why is he calling him? Why is he taking this? And why during this call, repeatedly, he is telling Relly, ask for a bag, meaning ask for money. Relly's telling him, I asked for money. He doesn't want to give it to me. Wally continually says, hey, basically, why are you taking it to the guys? Why take it to the boys? Meaning, why'd you bring the cops into it? He is doing the bidding for the defendant. And what's amazing, and again, it's not right, but the defendant, according to Relly, could have eliminated this whole situation by simply taking care of it with Relly. It wouldn't have been right. It wouldn't have changed what he did, but Relly apparently would have been on an island where we couldn't have found him. He didn't want to do it. His choice, his option, his consequences. Now, the defense said that we believe, this is a quote, that that tape is, quote, death to our case. I don't know what he means by death. That is not death to our case. That tape was the key to Relly's credibility if you believe it is important. In other words, that tape backs up every material point that Relly has made. Okay, believability of witnesses. In determining the believability of a witness, this is Calpern 226, you may consider anything that has a tendency to prove or disprove the truthfulness of the witness. Again, I'll be very clear. Twelvey and ASAP Lou came in there, and they repeatedly lied just about almost everything. I'm not going to go through all the inconsistencies. Twelvey didn't want to concede that he's reliant on the defendant, didn't want to admit that he's talked to the defendant. If you believe Twelvey and Lou, they've had almost no conversations about what happened in this case since the start. And if you believe Wally, even though Wally is, quote, mediating the situation, he's never talked to Rocky about it. He's never talked to Twelvey about it. How do you mediate a situation when you're only talking to one party? It's just not true. They lied. The difference between Relly and the defense witnesses is Relly was hostile. Relly was angry. Relly threw things. Listen, that wasn't appropriate conduct. You saw the judge. The judge was very frustrated with him. Everybody was frustrated with him. Listen, Mr. Proslenik, that was his witness. That's no easy task for him. But in the end, his credibility about what counts in this case was absolutely proven, and it was proven through their own witness. The evidence in this case, remember, we didn't have that tape. That tape came from Wally. We heard that tape only slightly before you did. Wally comes in and testifies, they play a snippet, and we play the rest. So when you're looking at the factors, you're looking at what witnesses are to be believed. They called 3 witnesses. All 3 of them perjured themselves. All 3 of them lied. All 3 of them came in to protect the defendant. And although they were calmer and more respectful, they perjured themselves in material areas. Relly, on the other hand, was truthful about everything that counted. So the defense focused on the fact that basically you can reject the testimony of Relly if you find that he lied about anything. However, Calpern 226 tells you do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. So listen, is it true that Relly, at points in time, was untruthful during his testimony? Absolutely. When he's saying, I don't know my girlfriend's name, of course he knows his girlfriend's name. When he's saying he doesn't know about a place in Miami that he purchased, of course he knows. But those differences, those inconsistencies, those conflicts, they're not only not important, they are completely irrelevant. In talking about ASAP Lou for a second, I'm gonna come back to that. Okay, let's talk about the injuries to Relly's hand. Now, the defense said, hey, prosecution, you did not call a witness to come in here and say that that is a wound from a gun. How is somebody going to be able to come look at an injury and tell you where it came from? Now, here's what you have to ask yourself. If there was something about that injury that was inconsistent, where it could not have come from a firearm.
On evidence.
Is this an exhibit?
It's not evidence.
I believe this is the correct exhibit. Is this a?
It's the incorrect.
Oh, you know what? Hold on, let me back it up. That's my fault. I have the wrong picture. Excuse me. The same. Let me change it. Thank you. Okay, this is the correct exhibit. So we're still talking about the injury of the hands. And you know, without question, that if there was an expert who could come in here and testify, you know what? Those injuries could not have come from a graze wound. They would have called that witness. And again, how do you know? Look at the team that's standing over there. Look at the fact that they called in Wally. The purpose of calling Wally, bring him out from France for thousands of dollars, obviously, was to simply impeach Relly with the fact that it was his voice. So if there was a medical professional who could come in here and tell you, well, that didn't come from a gunshot, you would have heard from them. And the failure to call a logical witness is something you can consider, and you should consider. And when the defense says, wait a minute, the people didn't call somebody in to testify, well, you have to ask yourself, if we call someone in to testify, what are we going to be able to get from them? Do you think common sense, you don't have to be an expert, who can look at an injury like this and say, yeah, that came from a bullet? You can. You can look at it and go, okay, could it be a graze wound? Sure. So if the defense had an expert that was going to say what they wanted, you would have heard from them. Okay, let's talk about Gills for a second. This was, again, the defense went all in on a couple of things. One of the things that went all in was that if there were casings at the scene, LAPD would have found them. Well, they didn't realize that the prop gun put out casings as well, and therefore the question isn't that LAPD missed the 9mm casings in this case. The issue is that without question, whether it was 9mm or the prop gun, it would have left casings, and LAPD missed it. Why? We'll never know. Why did Relly find it? Well, he had the advantage of knowing exactly where it was. Same thing with Ills. Again, the plan was clearly from these witnesses, and particularly from 12E, we're going to build up the fact that Relly gave Ills a beatdown. This had to do with his strength, how strong he is. He's punching him in the fist. Remember the judge? I still think there's a difference between a closed fist and a regular fist. But the judge, if you remember, when I mentioned closed fist, the judge said, well, a fist is a fist. It doesn't really matter. Their testimony was, and even today, you've got the defense saying how Relly is landing haymakers on Ills. They said that he was bleeding. Okay? Relly's a big guy. He's very strong. They said he was punched in the face at least 3 times. Well, I guess they didn't realize we were gonna have a video the next day, less than 24 hours later. And this is from the video. Look at his face. No injuries. No injuries. Nothing. Zero. Still photo from the video. Nothing. That is not the face of somebody that was punched in the face repeatedly, given a beating by a large, strong man less than 24 hours before. Someone who they said was bleeding from an injury to the lip where we see nothing. And by the way, where is Ills? Ills is his friend, Rocky's friend. If you think for a moment that Ills would have had something helpful to say in this case, they would have called him. And when they said, wait a minute, the people needed to call him, why on earth would it make sense for the people to call one of the three individuals who was clearly involved in ambushing Relly in the first place and who is reliant on the defendant for his career? If Ills had anything helpful, they would have called him.
The objection to verdict.
So I brought this up in voir dire, and this is really important, an idea that I wanted to make sure you guys understand. We mentioned that we might have to be a little bit aggressive on cross-examination. And I wanted to make sure, and I asked you all in advance, hey, listen, if we have to be aggressive in cross-examination with witnesses, are you going to hold that against us? You all said that you wouldn't. Now, whether you all found Mr. Przlenek to be too aggressive, too loud, too mean, I can't control this man. I could try, but it's impossible. And again, I make that joke because obviously, I'm an intense guy. This is a serious situation we're in. And Mr. Tacopina got up here, he explained to you what it's like to be a defense attorney, what it's like to have what he said is an innocent client. Let me tell you something. I want you to imagine right now that someone you cared about was a victim. What kind of prosecutor would you want? Would you want somebody who takes what they're doing seriously, who is aggressive, who does their job, and who goes after witnesses who need going after? So I'm not asking you guys to like me. It'd be nice if you did. That's not what this case is about. It's not about me, my personality. It's not about Mr. Tacopina's personality. It's about what the evidence of the case is. And there's a great quote. Professor John Henry Whitmore, Northwestern Law School dean, he also wrote a series of books, legal books. He was a scholar. And what he said was, cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. The defense put up 3 witnesses who lied about basically every material fact they were asked about. Those lies were exposed through cross-examination. Was it gentle? It wasn't. But that's what it took. And I want to apologize for it. I said before, I can't expect you all to do your job if I don't do mine. All right, let's talk about what the elements are of assault with a semi-automatic firearm, 245. 1, you don't need to actually touch someone with it. So the fact that did the defendant touch Relly with the gun on the first incident, it doesn't matter. By the way, he pulls the gun out. If any of you are buying the idea, as 12 said, that it fell out when his pants were being pulled up, then I'm up here wasting my breath. I would add that you're all intelligent people, and if anybody is even remotely considering that, I would ask you to ask yourselves and to ask them, is that what you think, or are you trying to find a way to not convict this man because of who he is? The issue of treating everybody equally, it's paramount to our criminal justice system. So, again, back to the elements, you don't need to actually touch someone. The evidence is that he did. You do not need to intend to use the force, meaning you don't have to pull that gun, meaning that you're planning on shooting it. You don't actually need to injure someone. You don't need to fire the gun. You don't even need to point the gun at the victim. This is in the instruction. And that also goes for the personal use of the firearm. Now, the one thing is, it has to be a firearm. And again, I'm going to go back to this because it's so important. The defense is it was a prop gun. That's the issue in this case. They say it's prop gun. They say all the evidence shows it's prop gun. We say it's firearm. Once you decide that it is a firearm, that means that their entire defense has fallen apart. And now what Mr. Tacopina apparently wants you to do is say, well, even if the witnesses we put on lied, even if it was a real gun, here's why it was self-defense. There's an old story about it's a civil case, civil lawyer, and he has a dog bite case, and he is defending his client with the dog, and they're being sued. The client is being sued because his dog has allegedly bitten somebody. He gets up and closes an argument, and he says as follows: "Hey, listen, my client's dog, there's no way he could have done any kind of damage to the plaintiff because he was on a leash. He was in the yard, could not have gotten to where he says he got. But if you find that he was loose, the dog's old, and he couldn't have done any damage with those old teeth of his. But okay, if you find that he was off leash and he had some big teeth, well, my final defense is my client doesn't own a dog." That's what we have here. It's no different. It's a prop gun. Absolutely a prop gun. Evidence doesn't show it's a prop gun, but it's a prop gun. But if you find it's not a prop gun, here's why Rocky fired a real gun in self-defense. It is almost insulting because it is so inconsistent. So when a defendant equips and positions himself to carry out a battery, he has the present ability required, even if some steps remain to be taken. This is basically saying once he's taken that gun out and he's committed the assault, when that gun comes out, at that point in time, the assault's done. So this is the 3470, the right to self-defense. And this is really important because remember, it only applies if it is a real gun and not a prop gun. But it's a little more than that, because what it basically says is you have to show that they are acting in lawful self-defense or of defense of another. The defense position in this case is that the defendant was acting to protect Relly and Gills. But it's more than that, okay? So basically they're saying that the defendant believed that he, Gills, and Twelby were in imminent danger, okay, of suffering bodily injury. And by the way, and you all know this, if someone is in danger of being touched unlawfully, you can't shoot them. okay? You don't have to actually go through jury instructions to figure that out, okay? If I go and I slap one of you guys, you can't shoot me. And why is that? Because he's got to believe that the immediate use of force was necessary to defend against the danger and that it was no more force than was reasonably necessary to defend against the danger. So what does all this mean? Well, they're basically claiming that the defendant used a prop gun, which means self-defense doesn't apply. So as soon as you find that out, you're done. But they're also arguing, hey, if you find, well, that it was a gun, even though that's not our argument. And Mr. Tacopina wouldn't come out and say it. But that's what the law is. If you don't believe me, you can ask the judge. Self-defense only applies in this case if it's a real gun. And the problem is, it also only applies if the force used was no more than reasonably necessary to defend against that danger. And now let's look at what that alleged danger is. There is no beating up of Ills, okay? There was no beating up of Ills. It's a lie. It's not true. You see the video. But even if somehow you wanted to argue, and you know it's a lie, because you can see that the gun, you can't see what the item is. So let's be clear. You can see Rocky pulling something out. You can't tell what it is, but you can then see that what he takes, he ends up putting out in front of him and aiming and shooting. That is what prompts Relly to grab Ills. They say, well, he had to use, I guess, and Mr. Tech can never argue this. He can't because it's inconsistent with his theory. But the theory would have to be that Rocky ended up firing the gun at Ills. I'm sorry, at Relly, because Ills was in imminent danger. What imminent danger? He's got no injury. It's made up. The defense is created. Didn't happen. Very important. Belief in future harm is not sufficient. So even if you somehow believe that Relly was going to cause future harm, it doesn't work. He has to have believed at the time that there was imminent danger of bodily injury. Imminent danger of bodily injury. Okay? That's what you need. It has to be reasonable, and he has to act because of that belief. You don't have it, ladies and gentlemen. That's why the defense didn't really argue it, because they are riding the boat. Their position is the dog was off the leash. So the dog was on the leash. Not that the dog had no teeth, and not that the guy didn't own the dog. But in the end, that's what their argument requires. You have to believe inconsistent defenses. It just doesn't work. Now again, the slightest touching, we're not talking about the slightest touching. They're basically saying that in the first incident, they're trying to argue that Relly is the aggressor when the facts in the video don't show it. Even if he grabbed his arm, no one says he has a weapon. You cannot pull a gun on somebody who doesn't have a weapon, who's not physically hurting you. You can't threaten him with a firearm. I mean, I don't have to explain that to you all. You understand that. You can't do it. It doesn't work. So we have the burden of proving that beyond a reasonable doubt. However, again, it doesn't come into existence until you find that it was a real gun. And once you find it's a real gun, it means their entire defense was fabricated. It wasn't true. Automatically, there's no way that it could be a real gun and the defense was not fabricated. Those are impossible. Those are mutually inconsistent possibilities. And when I say possibilities, meaning alternatives. So, a person who starts a fight has a right to self-defense. Relly did not start this fight. The defendant started this fight. And he has to actually, in good faith, he's got to try to stop fighting, which he doesn't. He's the aggressor. Both incidents. And in no way is element 2 satisfied either. So you can play games debating how a self-defense claim that the defense is not even relying on doesn't apply to the case, but you know that. Their defense is, no question, it's prop gun. A person also cannot claim self-defense if they are the one that provokes a fight or quarrel with the intent to create an excuse to use force. And that's what happened here. Relly didn't even use any force. Basically, the defendant assaults him with a firearm because he's mad at him. Shoots at him again because either Relly said something or he's still angry. So, in the end, the statements, Terrell gave a lot of statements in this case. And about all the issues that matter, he was consistent. Now, they want to say, but wait a minute. He originally said it was 3 to 4 shots. And imagine for a second. Remember, he doesn't know in advance the defendant is going to shoot. So his memory, and you can all, it's not hard to imagine, you're in a situation where you believe you're fighting for your life. How do you know that Relly was fighting for his life? He's telling Wally he was fighting for his life. He's saying, the defendant tried to take it from his daughter. He believes at the time the defendant has fired 3 or 4 shots. And when he talks to Wally, he says 5 shots. That doesn't matter. That's not a question of credibility, and here's why. If Relly were making this up, and remember what they're saying. They're also saying that Relly had to have planted the 9mm casings, okay? And let's talk about that for a second, because it's important. They are saying, hey, listen, Relly was out here 2 weeks before this shooting, and we don't know that he went back home. So apparently, Relly planned this out in advance. He got 9mm casings from when he went target shooting, knowing that 2 weeks later, the defendant would be upset with him, would text him repeatedly, and would assault him with a 9mm firearm, and he would have casings ready to put at the scene. But just to make it extra difficult, he's going to tell the cops, you know what, I got shot 3 or 4, there were 3 or 4 gunshots, but he's only going to turn in 2 casings. So remember, if he's making up this whole thing, which of course he isn't, he is certainly going to produce the amount of casings at the scene that he is saying happened. That's an irrefutable concept. And that's not what occurs. And the idea that somehow Relly is Nostradamus and knows all these things are going to happen. And let's look at what had to occur. It's 10 p.m. on a Saturday night in Hollywood. Relly doesn't live here. We know from ASAP Lou, he can't go out and buy ammunition. He doesn't have a gun. So he certainly could not have, after this incident, bought a gun, fired the ammunition, and dumped it at the scene. So that means that he's carrying around 9mm casings just in case the defendant assaults him. It's absurd. Then they say, well, wait a minute. You know that it's made up because look at the magazine that's found at the defendant's house. And now we go back to ASAP Lou. Listen, ASAP Lou, Chris Lemick, he really covered it pretty accurately. He's the Swiss Army knife of assistants, advisors, security stuff. You need a personal assistant, lose your guy. You need someone to give you advice on security, lose your guy. You need someone to come over to stay for a search warrant, lose your guy. You need someone to help you get a prop gun, lose your guy. You need someone to get rid of that prop gun after an incident where that prop gun will prove you to be innocent, lose your guy. Lou's version of what happened is nearly impossible. What is that version? And this is really important because remember, we didn't find out about it at the time. So here's what we know. The evidence in this case that you have, and I confronted the witnesses, is that 12E testified that what he told the defense, what was in the statement we were given, was that The defendant decided to carry a prop gun because he had been the victim of home invasions and violence. Let's just look at that for a moment. Nothing about any particular incidents. And then he gets on the stand and he starts testifying about all these incidents. But he says, oh, well, I told them. I told them about it. I think I told them. I guess I don't know. These alleged incidents of prior violence. And supposedly there's a security person. Just think about this for a moment. 12, testifies that the defendant and he were stabbed at a club with a knife. That there's been a crazy stalker inside the defendant's house. That he's been the victim of other violence. And we're to believe that a security consultant said, hey, you know what you should do? You should carry a fake gun. Because individuals who are going to, and by the way, a home invasion, defense counsel, wait a minute, it's different when you're at your home. That's what 12E said. Those were his words, home invasions and violence. Someone comes in your home. How is a prop gun going to help you? How is a prop gun going to help you against anybody? As soon as you pull a prop gun on somebody, they are going to believe that that prop gun is real. And if they have their own weapon, out of necessity, they're going to have to fire back. It's not just bad advice, it's complete insanity and it's made up. But the situation here is even worse, because remember, they're saying that Relly knew it was a prop gun from the start. If he knows it's a prop gun, then what is the use in Rocky pulling it out in the first place? It would have no value. Relly said, of course I didn't know it was a prop gun. It wasn't a prop gun. It shot me. But the idea, you don't even need Relly's testimony. The idea, they're the ones saying, their defense is, Relly knew it was a prop gun. He stands up and says, put that fake ass gun away. You look at him in the second incident. Is he acting like that's a fake ass gun? Is anyone acting like it's a fake ass gun? Is the defendant acting like it's a fake ass gun? Of course not.
Thank you,
Because it
Audrey.
wasn't fake.
Thank you for the
And
blessing,
now let's
Audrey.
look at Lou. Lou says, well, so here's what happened. Originally, we hear nothing about the circumstances of I went over to the house and we were going to go shooting. We don't hear any of that. All that he says, now he said, I might have told the defense, I might not have, I don't remember. I didn't get into particulars. Are you kidding me? It's the entire case. But all of a sudden, he gets on the stand and he says, for the first time, well, here's what happened. I was going to teach the defendant, we were going to go shooting at a gun range. So I brought my Glock 380, which does not use 9mm ammunition, and I brought my Smith & Wesson 9mm, which cannot use a Glock 9mm Glock 43 magazine. It won't fit. They don't even look anywhere the same, and that is from Lou. Look completely different. He says, he gets over to the house, and that's when he realizes for the first time, oh my God, I bought the wrong magazine for my Glock. Now, does it make sense that he felt a need to go out and buy a magazine for his gun, and then did not find out for some period of time, he wouldn't say where he bought it, when he bought it, and it was not for the right gun, but he made another mistake that he clearly wasn't aware of. I confronted him with the fact, he says, well, so I realized that when I was over there, I tried to put the 9mm, the 380 ammunition in, and it wouldn't fit. Okay. But why was it found loaded completely with 9mm ammunition? As soon as it didn't fit, he would stop. And that's just, well, I'm a fidgety dude. So while I was drinking, I was fidgeting, just loading a gun, loading a magazine for a gun I don't have and the defendant doesn't have. They spent a lot of time telling you, well, wait a minute. That magazine is new, hasn't been used. I asked Lou, isn't it true, Lou, that when you buy a new gun, most of the time they come with 2 magazines? Well, I don't know, I usually only buy 1. Well, it's interesting because he clearly went out and bought a second magazine for the .380, so not quite understanding what that means. But what is very clear, ladies and gentlemen, is here's what happened. Lou doesn't own a Glock 43. He's never had one registered, so he has no reason to have a magazine for a gun he doesn't own. The defendant doesn't have a Glock 43 magazine. He has no reason to have a Glock 43 magazine for a gun he doesn't own. However, there is evidence that suggests that the gun that was used in this crime was a Glock 43. Doesn't have to be, but it is consistent with the evidence. And what is clear is that the defendant got rid of the gun after the incident. Now, he says the gun he got rid of was a prop gun. That's not what the evidence shows. He got rid of that 9mm and the magazine that went with it. But he clearly forgot that in his closet was a second magazine for that gun. A magazine that clearly was not being used in that gun and very well might have been new, because he was using the magazine that was in the gun when it was fired at Raleigh. So Lou's version is completely impeached, but it's even worse than that. So they apparently have this information. Twelvey and Lou have information about this product that will completely prove that the defendant did not commit this crime. And when does it get turned over to prosecutors and police for the first time? January 20th, the day before this trial started. Now they say, oh no, but actually, we told them about it in August 16th or 17th of 2024. That's still almost 3 years after the incident occurred. Remember, ASAP Lou is at the house when the search warrant is served. He didn't even have to go to the police. All he has to do is say, hey, you know what? That magazine, that 9mm magazine, that's mine. By the way, it was a prop gun that he had. Nothing. You know why he didn't say it? Because he hadn't made up the defense yet. That's why. Do you know why Twelvey didn't say anything? Because he hadn't made up the defense yet. That's what the evidence shows. And then what happened? Literally on February 9th, the morning that Lou was going to testify, we are given information. Oh, it turns out that Lou gave the gun to somebody in New York. And that's why they don't have the gun. Now remember, we're finding this out on what is basically the last day of the trial. We don't have the ability to get that person. But the defense, that's someone they've known about all along. Where is he to testify about this gun? They're saying we have to bring this person out here when there's no reason to believe that anything that person is going to say is true. But we're supposed to bring that person out here who we don't even know exists to prove that it's not a prop gun. That it's not a prop gun when that's their witness. Do you not think for a moment that if that witness could have withstood cross-examination, they would have brought him out here? Of course they would have. And how do you know that any of this is true? Because you're instructed on it. So the defense spent a long time attacking me, primarily me, attacking Relic. Where is the instruction about evidence that I ended up fabricating? It says if the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he was aware of his guilt. What does that mean? That instruction is because the defendant, by his own, meaning the defense admission, through their witnesses, is that the defendant got rid of the prop gun, the piece of evidence that would demonstrate that he's innocent of these charges. that he got rid of that gun after the incident. The judge isn't going to give that instruction unless that instruction is something you can consider. Not going to do it. What does it say? If the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he is aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. So in other words, just because the defendant got rid of the gun, that's not enough to prove to you by itself that the defendant is guilty of these crimes. But when you put it with everything else, it is a huge piece of evidence. If someone other than the defendant tried to create false evidence, provide false testimony, or conceal or destroy evidence, that conduct may show the defendant was aware of his guilt. But only if the defendant was present and knew about that conduct, or if not present, authorized the other person's actions. Circumstantially, the evidence suggests that ASAP Lou and Twelby and Wally are not doing this on their own. The evidence, the direct evidence from Wally is that he talked to the defendant immediately afterwards, their conversation. The idea that ASAP Lou and ASAP Twelby were not having repeated conversations about this incident strains any even idea of reality. You all know that's not true. Of course they talked about it. Obviously, it's a huge incident that occurred. So that is an instruction you were given. It doesn't say anything about Relly. There's no instruction like that for Relly in this case. Flight. If the defendant fled immediately after the crime was committed, that conduct may show that he was aware of his guilt. What does that mean? After the incident, guys, the second incident, he takes off. If it is in fact, if it was simply a prop gun, why is he running? Why is Twelby running? Why are they getting out of there? Why are they getting rid of the gun? I mean, I'm trying to argue, you guys, why is the sky blue? And I hope that when you're listening to it, I hope you're all understanding this is not a complicated, complex case. In the end, the evidence in this case, almost all of it, it's not circumstantial. So the video is direct evidence. It's direct evidence of what happened. The testimony of the witnesses is direct evidence. Relly's statement on the call is direct evidence. The testimony, as incredible and unreliable as it is, of Wally, of Twelby, and of ASAP Lou is direct evidence. This is not a circumstantial evidence case. About the only circumstantial evidence in this case that you have that matters is circumstantially we have to prove that the defendant pointed the gun at Relly in the first incident because we don't have it on video. But we've got his gun being pulled out, we have his gun in front of him, and we have Relly in that position. We have him fighting with Relly right before and fighting with him right after. So the only reasonable interpretation of that circumstantial evidence is what you're seeing. Defendant's failure to call logical witnesses. This is really important. I've mentioned this before. Every argument that the defense made, the defense, and again, I'm not blaming Mr. Tacopina. The witnesses got up here and lied. Mr. Tacopina gets a statement from the witnesses. The witnesses say what they're going to say. He calls them. Mr. Tacopina does not vouch for his witnesses, meaning, just as we don't. We call witnesses, and those witnesses testify, and you evaluate them. However, it is certainly legitimate that all these individuals that the defense is saying, why didn't the people call them? Those are witnesses that they are saying we have to introduce to disprove their fabricated defense, which we don't have the ability to do because they control that evidence and information. They've got the prop gun, we don't. They have these witnesses they don't tell us about, we don't. We have proven that this was not a prop gun in every way that we can. It defies common sense, it defies logic, and it defies all the other evidence that we've been given. Now listen, I'm not blaming the defense for what they've come up with. When life gives you lemons, you make lemonade, okay? That's what they've tried to do. They have tried to take a case, and they got bad luck. Imagine, guys, for a second, if we didn't have those video cameras. Imagine what the defense would be. Well, you can't show anything happening. This is all made up. You got nothing. But we have the video. We have the gunshots. That's bad luck for the defendant. And again, that situation he made, that's his luck. Now, one of the things that's going to happen is you're going to go back there, and we talked a little bit about this before. Let's assume that somebody, when you go back there, starts saying, what if, isn't it possible that, could this have happened? You are not allowed to speculate outside the evidence. That also goes for things like, well, gosh, what if Rocky gets prison on this case? I don't want to go to prison. If any one of you feel that yourselves, you need to let the court know, I can't serve as a juror on this case. That's okay. Some of you during voir dire at points said, I don't know about certain things. And if you remember, the judge told different jurors, hey, listen, if at any point in time you cannot live up to your oath, let the judge know. If one of the rest of you decide, I'll give you an example. Let's say someone goes back there and they say, you know what? I really dislike DDA Logan. I don't like him. I didn't like him when I saw him. He's obnoxious, etc. Whatever. If that is what you are basing your verdict on, it's improper. It's misconduct. If someone says, I'm never going to convict on a case because I don't like Logan. If it's you and you can't get past it, you need to report yourself to the court. If it's someone else, they need to do it. We don't know if misconduct happens unless you let the court know about it. So if people, yourself, others are not living up to their responsibilities, we need to let everybody know. That goes the same for the celebrity issue, okay? The defendant should not be convicted because he's a celebrity. But he also should not be acquitted because he's a celebrity. He should not be acquitted because he's got a lovely family. He should not be acquitted because he's successful and wealthy. He should not be acquitted because he can go out there and entertain people and make millions of dollars. Those are factors I'm not just recommending, you're not allowed to consider those factors. All you're doing is you're going to weigh the evidence in this case and you're going to come to your decision. Reasonable doubt in this case. So, proof beyond a reasonable doubt is proof that leaves you with an abiding conviction that the charge is true. The evidence need not eliminate all possible doubt because everything in life is open to some possible or imaginary doubt. What does that mean? Well, it simply means that you're going back and you're going to look and you're going to say to yourselves, okay, here's the case that people presented. The people have presented evidence that the defendant used a real gun. Have we proven that it was a real gun? Not just from our case, but from the evidence that the defense put on as well. They've argued this is a prop gun. And when anybody goes back there and says, well, wait a minute, I don't like Relly, I don't find Relly credible. The problem is, what do you need to find Relly credible about? The evidence is they're admitting it's him. They're admitting it's a gun. They're admitting he fired it. They're admitting that's him at both locations. The only thing that they are really disputing is they're disputing that Rocky ever put the gun up to him in the first incident, which, by the way, once he pulls it out and he's pointing it and you can see it, he doesn't have to point it at him, but once that gun comes out in that situation, you can read the elements of 245. They've met it. The second incident's easy. He actually fires the gun. So where exactly is Relly's credibility? Where is it material? It isn't. They have put Relly on trial in this case because in the end, he is a very convenient target. Legally, it doesn't work. Commonsensically, it doesn't work, but that's what they've argued. You can come and should come to the conclusion in this case, beyond a reasonable doubt, based on the video and based on the defense in this case. But if you need Relly's credibility, the best evidence you have comes from Wally, their witness, and that tape. That's the only thing you need to listen to. Any testimony in court, that's in court. Everyone knows why we're in court. That is the one piece of evidence coming from the defense where there's no argument that Relly knew he was being taped. There's no argument that he had any incentive to be untruthful. And you listen to him and you know what he is saying is true. He is shocked. He is basically telling Wally, dude, I tried to get money from him. He don't want to give me any money. Why'd you bring the boys in? He won't give me any money. He tried to kill me. He tried to shoot me. No question. By the way, Wally never mentions it's a prop gun because the defense had not been thought of yet. We started off in this case very early on. We started off with the situation with Boomer. And Boomer is a very important illustration of the difference between what's reasonable and what's possible. And as you remember, we know what happened. We know that the evidence demonstrated that Boomer was the one that got into the trash. And the evidence has demonstrated in this case, beyond any reasonable doubt whatsoever, that the defendant hears that on November 6th, 2021, that he committed these crimes. I'm going to end with this. We've done our job in this case. We have. We've put on more than enough evidence through our case, through the cross-examination of witnesses. We've done our job. I'm going to ask you all to do yours, whether you want to convict the defendant or not, based on the evidence. That's what you're compelled to do. Because we can't have individuals, you can't have it, deciding that because they're angry, or they're upset, or they've been disrespected, that they're going to be allowed to go out and shoot at people on the street on a busy Saturday night. We cannot have it. As you go back there, and I'm going to say this again, the first thing that I would ask you to do is to decide, was this a prop gun or not? And if you decide it is a prop gun, for those of you who do, you're going to have to get past all of the nonsensical evidence in this case. You need to ask yourselves, are you following the evidence? Are you following your head, or are you following your heart for whatever reason? Once you do that, the case is over, because that means the defense is fabricated. That means it was a real gun. That means you can't believe anything that was said by any of their witnesses. And that means that in the end, the defendant used a real firearm and committed these crimes. Again, as defense counsel stated, I want to thank you all for your time and for your attention. And I too want to thank Judge Arnold. It's not been an easy case. And I want to ask, to the best of your ability, when you go back there, you pretend that he's not ASAP Rocky. You pretend that he's just a guy named Rakeem Mayers. And you treat him the way you would treat anybody else who was accused of these crimes with this evidence. And when you return a guilty verdict, that is not on you. That's on him, because that is what the evidence has demonstrated. Do not let anybody tell you that you own his conduct. He owns it. On November 6th, he made a very foolish decision, an illegal decision, a criminal decision, a decision that could have hurt individuals far worse than what happened. And it's your job and your responsibility to hold him accountable. Because if we're not going to hold privileged people accountable, who are we going to hold accountable? Again, thank you for your time and attention.
All right, so the state has just finished, and so yeah, so now we got to figure out, because now it is almost 4 o'clock on the West Coast, so we're gonna see if they're gonna let the jury go home and deliberate Tuesday or deliberate tonight. It is Valentine's Day, and these people, they probably don't want to deliberate on Valentine's Day, but they got to do their civic duty, though. Their civic duty calls before anything. So they have to do it. It could be any one of us called for jury duty. We have to do it. Sometime we're called to do it. But they should get the case tonight, though, right now. How long would they deliberate for? I don't know. I don't know. I don't know how long, but it looks like they might continue. I don't know. Yeah, the judge read it. He's like, man, I might as well call it a day. But he might not, though. Yeah, until 7 p.m. That's what I say on the West Coast. So that's 10 our time. East Coast time. 10 East Coast time. He said the judge is tired of this. So like I said, it was breaking news. I had just uploaded a video just now as this was going on. I made a video real quick. Jay-Z and Puff, that case where Jay-Z was involved in, where the girl said she was 13 at the time. She dismissed the case, which means that she dismissed it with prejudice, without prejudice, with prejudice, meaning that she can never file the case again. It's over. So Jay-Z scored a victory. His lawyer fought that case tooth and nail. He said, y'all not doing this to us. She lying. And Busby filed it, and they dropped the case. Dropped it. It's over. They dropped it. So when people were saying, no, Max, they got evidence, and Tony ain't no joke. Okay. They dropped it, though. They dropped it. Jay-Z wasn't pleased. I'm going to show you how different I really am. Jay wasn't joking. I think it was that case probably was like, let's see if they did something. Let's see how they react. Jay innocent, man. I keep trying to tell people he clean. Nobody believes me though. They want him. It's like they want him to go down. All right, let's see.
Instruction on circumstantial evidence. It's jury instruction number 224. Jury instruction number 224 tells you everything you need to know about circumstantial evidence. There was some question about whether it was shown in its entirety. The entire jury instruction is in 224. Another thing I want to mention to you is I think it is very obvious that everyone at that table left it all out of the field. Everybody put out 150%. I think that's very evident. Correct. I want to hopefully focus your duties by kind of summarizing something that both sides have mentioned to you. All right. The people have the burden to prove beyond a reasonable doubt that the gun was real. If the people have not proven beyond a reasonable doubt that Mr. Mayers used a real 9mm, then the verdict is not guilty. If you do find that the that the gun was real, then you look at the 5 elements that are listed for assault with a semi-automatic pistol. That's jury instruction 875. You have to decide whether those elements, all 5 elements, have been proven beyond a reasonable doubt. Then also, you can consider the jury instructions on self-defense and the defense of others. You have that jury instruction as well. So I'm hoping that this assists you in kind of focusing how you deliberate. All right, I'm going to read the 2 final jury instructions. When I'm finished with this, I'm going to send you to where you're going to be deliberating. You won't be deliberating in the jury deliberation room here for this court. You'll be deliberating in the deliberation room that is from my court, which is Department 115 on the 11th floor. So when I release you, I'd like you to go to the 11th floor and go to Department 115. Department 115, it's right there when you get off the elevators. And Alex will meet you up there. He'll escort you into the jury deliberation room. You can take all of your materials, you can set them down, and you can leave for the day. On Tuesday, you must be here by 9 a.m. Jury deliberations start at 9 a.m. And when you show up on Tuesday, you're to gather outside the courtroom doors of Department 115 on the 11th floor. Do you want to say something?
Yes.
Same thing?
If it's not too much of a problem, can we start at 9:30? If possible, if everyone's okay with that.
Is that what you all want? All right, I'm seeing nods. Yeah, all right, 9:30. 9:30. All right, here are the final 2 jury instructions. When you go to the jury room, the first thing you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you have discussed the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family or friends, spiritual leaders or advisors or therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. Do not communicate using social media during your deliberations. It is very important that you not use the internet in any way in connection with this case during your deliberations. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room when you begin to deliberate. I made arrangements for a screen, a projection screen, to be brought into the jury deliberation that's actually bigger than that. So if you want to review the videos, you'll be able to do that. We're going to need a clean computer though,
Okay.
they can use. You've got to connect the computer to the projector, which is connected to the screen. Mark, our audio visual guy, he can show you how to do that if necessary. If you need to communicate with me while you are deliberating, send a note through the bailiff signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by a written note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case unless I ask you to do so. Your verdict on each count and the special finding of the firearm allegation must be unanimous. This means that to return a verdict, all of you must agree to it. Do not reach a decision by the flip of a coin or by any other similar act. It is not my role to tell you what your verdict should be. Do not take anything I said or did during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. You must reach your verdict without any consideration of punishment. You will be given verdict forms. As soon as all jurors have agreed on a verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff. If you are able to reach a unanimous decision on only one of the charges, fill in that verdict form only and notify the bailiff. Return any unsigned verdict form. To the alternate jurors, the jury will soon be deliberating, but you are still alternate jurors and you are bound by my earlier instructions about your conduct. Do not talk about the case or about any of the people or any subject involved in it with anyone, not even your family or friends, and not even with each other. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted in for one of the deliberating jurors. Will the clerk please swear the bailiff?
Yes, Your Honor. Please raise your right hand. Thank you. You solemnly state they will take charge of the jury and keep them together. You will not speak to them yourself, nor allow anyone else to speak to them on matters connected to this case, except by order of the court. When they have agreed on a verdict, you will return into court. Furthermore, they will take charge of the alternate jurors, keep them apart from the jury, whether it be levying on costs, until otherwise instructed by the court, so help you God.
Thank you.
All right, the case is now yours. Alex is going to meet you on the 11th floor in front of Department 115. He will escort the 12 of you into the jury deliberation room. You can put your materials down and then you can leave for the day. Remember, 9 o'clock Tuesday, 9:30 Tuesday, please be outside the courtroom doors, not here, Department 115 on the 11th floor. For the four alternates, I'd like you also to go up to the 11th floor now, and what I'm going to want you to do is to give Deputy Bennett your contact numbers. I assume you all have cell phones? All right, I'd like you to give Deputy Bennett your cell phone numbers,
so we can reach you in case we need you. And if we do call you, we're gonna need you quickly. So while the jury is deliberating, you could be in the hallway, you could be in the jury assembly room downstairs, you could walk around, you could be in the cafeteria, but you have to be ready, willing, and able to come to the courtroom if you're summoned. All right, you folks are going to be excused now. Take all of your materials. Council needs to remain. We have a couple of council.
Your Honor, what should the alternates do with our materials?
Yeah. You can leave those. We have chairs upstairs in Department 115. You can just find a spot and you can leave them there. Everybody take all of your transcripts, notes, notebooks.
All right, so he's letting them enjoy their holiday. So they're going to be deliberating Tuesday. So Tuesday, they're going to start deliberating. So at least he get to enjoy the weekend. You know, Valentine's Day, the weekend, Monday, and then he come back Tuesday and see what they do. See if they enjoy it. I mean, see if they come up with a verdict. So that's what's going on right there. Maybe they'll come back because they said the attorney's got to go over some stuff, but all right, let's see.
That Mr. Mayers is found guilty. The aggravating factors that come into play. Obviously, he's found not guilty. The aggravating factors have no relevance to anything. What I want to know is whether, if there is a conviction, how you want to deal with the two aggravating factors. What I mean is, you want the jury to make a finding as to whether they're true or not, or you want to let the court, me, at some time in the future, make that decision. What about all right, in the event that the aggravating factors become relevant, you have a right to have this jury determine whether or not the aggravating factors are true. And they have to make that finding beyond a reasonable doubt. The jury can do it, or I can do it. Whether the jury does it or I do it, the standard of proof is proof beyond a reasonable doubt. Now, Mr. Tacopina has stated that I can make that decision rather than the jury having to make that decision. Do you understand that? Absolutely. Do you waive your right to have the jury make the decision and agree that I can make that decision in the near future, when it becomes necessary in the future? Jordan? That's it. All right, the next question is readback. If there is a readback, request for readback of testimony, what I want to know is whether both sides are willing to waive their presence and agree that the court reporter can go into the jury deliberation room and provide the readback of testimony. However, both sides will know what that readback is before it's ever provided.
I agree. We're on that, also an agreement what's going to be read to them. Right?
Any communication from the jury, whether it's a request for readback or a question, will be given to both sides before any response is given to the jury. If there is a request for readback, all of you will know what the request is and will hammer out what readback will be provided.
With that, then we have no problem with the court going back.
All right. Again, Mr. Mayor, you have a right to be present for the readback of testimony. What would happen is the readback of testimony would happen in open court. And you would be there, your lawyers would be there, the prosecutors would be there, and I would be there. In the alternative, you can waive your right to be present. So what would happen is if there is a request for readback of testimony, the testimony would be provided, but it would be the court reporter going into the jury deliberation room and providing the readback the testimony that is requested. And you won't be in there, your attorney won't be in there, prosecutors won't be there, and neither will I. Do you understand? Do you waive your right to be present? John?
Yes.
All right, the last thing is, I thought that 1 hour call would be appropriate, meaning that if the jury summons that they have reached a verdict, that the verdict would be read an hour after they have made that notice. Do you have any response? Do you think it needs to be more than that, less than that?
I mean, no, it should be fine. I mean, obviously, no, it should be fine.
Oh, that reminds me. Mr. Mayor's, well, under the circumstances, Mr. Mayor's needs to be here within 1 hour also.
Yeah.
All right. People, do you think 1 hour is sufficient?
That's fine. If we could, an hour and a half would be easier, but if the court wants an hour.
Well, I can make it,
90 minutes would help us. I'm guessing.
I'm fine with that. I don't care. That's fine. If you want 90, that's fine.
all right, we'll do 90 minutes, and if everybody can gather before that, okay? But it'll be 90 minutes from the time that we're notified that there is a verdict. What I said to the jury, that all of you left it all in the field, I mean that. You all put out 150%. So you did your clients proud. All right, anything else to
David, we did have one.
Just one thing. So during the PowerPoint presentation by the people, they played the video from 1616 East Del Mar. And I can't be certain of this, but it appeared to us that the sound of the first shot was played earlier on the video they showed to the jury than the one that they presented in People's Exhibit 15. So just before we leave here today, if we can just look at the PowerPoint presentation to confirm that the video was the same video admitted as People's Exhibit 15 would be fine. If the shot was actually moved, if they modified that video in some way, we'll have to figure out some type of remedy, but I just wanted to clear that before we bring it today. If that's okay.
Nothing was modified anyway, or we took the videos that were admitted and we used them in PowerPoint. I do not believe that I need to sit down with counsel and go through, the court certainly within its authority in ruling that that is an insignificant issue. The court has seen the evidence that's been presented, so I'll leave it up to the court.
The jury has the exhibits, so I'm going to deny that request.
Your Honor, if there was evidence on it's not an insignificant issue as to whether or not the shot occurred before Relly went to Hills. It's a significant issue in this case. In fact, the people now are letting us look at it, particularly after they tried to present an exhibit of knuckles that weren't in evidence. It's disconcerting. The court's not going to let us look at it. It is what it is.
All right. I think that showing the exhibit of Relly's knuckles, I don't think that was intentional. It was an oversight. Mr. Lewin said it was an oversight. It was a mistake. We're all human beings. We make mistakes. The jury has the exhibits. The exhibits are what matters in this case, not the PowerPoint presentation. Where was that?
There he is.
Oh, there you go. That's what did you want to bring anything up?
No.
Mr. Kozlovic, anything? Mr. Lewin?
No, just a reminder on the caption.
Yeah, I forgot that. Thank you. All right, well, all right.
That's a wrap. Thank you.
That's a wrap. Yeah, he's probably going through his mind like, okay, I did this, I said that. I think the jury's gonna hear it. I think the jury's gonna side with me, But they gotta try to enjoy their weekend somehow. That's it. Yep, that's it, man. Yep, they got to somehow, enjoy it. Oh, that's that. Always go to this, that flight channel. But yeah, man, that's it, man. That's so what do you? Let me see what the All right, so not guilty 28%, guilty 58%. So that's a little different from yesterday, and 14% hung jury. So that's the poll right there. 57 to 28%. So we're gonna see. We're gonna see if the prosecutor met his burden to the jury. Some problem areas in that case is that, nowhere in those conversations they mention a prop gun. So yeah, that's something else right there, man. Way different from yesterday, I know. It's a huge difference. But yeah, we'll see if they side with the jury. Yep. See if they side with the jury, man. See what happens. But yeah, man. So Tuesday, so we'll know we'll be back Tuesday to check it out. Let's see. So Tuesday is the 18th. Yeah, that's gonna be rather interesting, man. To see what the possibilities are, man. To see what happens. Yeah. You said asking for my 10-4 hat friend. I don't know. That's a hell of a sacrifice. Boy, he in some pickle. Yeah, he had to sit and listen to it. It's crazy. But anyway, guys, I'll be back at some point, probably a little later. But thanks for watching. And yeah, man, I'll be back in a few. Talk about something else. But yeah, we'll be back. Definitely be back Tuesday. All right, y'all.